So we really had not a lot of thoughts about what might happen in the postseason. We just wanted to win our division, win the conference, host the conference tournament, then host the regional tournament. And those are all building blocks and steps along the way. If you miss one of those steps, it's pretty hard to advance. So we just focused on the next thing and the next opponent. And we had a tremendous group of players. We had guys who were experienced, athletic, and for the most part, we had kept our composure.
light comes on and that'll activate the mic.
Okay.
Okay?
Cool. It's easy.
So red is good. Okay.
Test, test.
We can leave in the stand too. Stand.
Hopefully I won't have to.
Test, test, test.
It's not on right now.
Good morning. As people seem to trickle in, thank you guys for joining us this morning. Good morning, my name is Megan Marshall. I'm president of the State Board of Pharmacy here. Appreciate you guys being very hospitable to us today and in welcoming us into your college. As people are trickling in, we'll kind of go over as to what we're going to be doing today and be able to share with you our board meetings here at the University of Findlay. So what we want to do before we get things rolling here and kind of go over as to what we're going to be doing today, I'll have each of the board members go ahead and introduce themselves to you. I'm going to give you a little bit about background as to who we are and our terms, how long we've been on the board, as well as what we do and what we've been, how long we've been on the board, excuse me, as well as where we practice across the state of Ohio. So I'm going to have Ms. Yarsh start us off down there.
So good morning, everyone. My name is Kylie Yarsh. I'm a graduate of Duquesne University. This is my first year of my second term, so my 5th year on the board. I am currently the Market Director of Pharmacy for Valley Care Health System in Youngstown, Ohio. I live north of there in Jefferson, so Ashtabula County, as far north as you can get. And my practice has included retail, hospital, as well as nuclear. So welcome, thank you all for having us today, and please ask us any questions as we go through the process.
Hello, my name is Jen Rudell. I am just finished my first year on the board, so about a year and a half now. I went to the University of Cincinnati, live kind of on the northern end of Cincinnati by Kings Island, if anyone's been down that way. I work for CVS Health. I manage 21 stores in the Dayton, Ohio market, northern Cincinnati and Dayton, Ohio. And thank you for having us here today.
Good morning, everybody. My name is Kurt Pasifune. I am in my 3rd year on the board. My day job is the Chief Pharmacy Officer for Ohio Health, a health system in and around the Columbus area. I also have the honor of serving as the board delegate and the chairman of the Medical Marijuana Control Program Committee, Advisory Committee, and so we are in the midst of launching that program here in Ohio. So between the board and my day job and that, I'm pretty much all in pharmacy these days. So thanks for having us, appreciate your hospitality, and look forward to interacting with you further.
Good morning, my name is Sean Wild. I am a graduate at the University of Toledo. I am the Pharmacy District Manager with Meyer Corporation. I supervise Toledo and Northern Indiana, and I live in the Toledo market. Thank you, I love being on your campus.
Hey, good morning. My name is Fred Weaver. I am currently serving my 2nd term on the board. I am privileged of serving as Vice President to Ms. Marshall. I'm a graduate of the University of Toledo and I'm currently employed with Giant Eagle. Thank you for having us.
My name is Dick Newland. I'm the public member of the board. I come to the board after 46 years in small business and 20 years in the Methodist, as a United Methodist pastor. For you mathematicians, a lot of those years were simultaneous, so don't do that to me. But it's an honor. I've been on the board. This is my 4th meeting, and just an honor and a joy to be with you folks this morning. Thank you.
And my name is Megan Marshall. I am serving my 2nd term. It's my 1st year of my 2nd term, currently serving as president this year. I've been honored and nominated by my fellow board members for this privilege. I currently practice at the Ohio State University Outpatient Pharmacy as their clinical and outreach coordinator. So I help coordinate the work processes between my doctor's offices on the outpatient clinic side and ensuring that my pharmacists and our pharmacy is working with all the clinics within Ohio State, across the entire Ohio State Medical Center. So we appreciate everything that you guys have, like I said, have welcomed us in. What I would like to do now is, actually, we are missing 2 board members. If you haven't seen, we are down 2 board members right now. We actually have 2 that weren't able to join us today. Mr. Michael Monet, he practices with Cardinal, and he is in his last year of his 2nd term. He has some other outstanding events that had to pull him away today, and also Joshua Cox. He is the director of pharmacy with an oncology hematology group down in the Dayton area, so he was unable to be with us today as well. So, and seeing as though we do have a quorum, we are able to proceed forward with our meetings today. At this time, I would like to have Mr. Shearholt introduce himself, and we'll turn it over to Ms. Rudell after that to just understand as to how the process of the meeting is going to go today for you.
How's this? I obviously don't have the touch.
Well, good morning. My name is Steve Sherholt. I am the board's executive director and have been so for about 2 years and 11 months. My career has been in law enforcement. I've been in law enforcement for 40 years now, and actually after leaving the military, my first civilian law enforcement assignment was here in Findlay, Ohio. I worked with a drug task force here buying drugs, and did that for a couple of months, maybe 3 months here in Findlay back before any of you were born. Again, my career has been in law enforcement. I have served as the executive director of the Ohio Peace Officer Training Commission. I have served as the assistant superintendent of the State Bureau of Criminal Investigation, have served as an assistant prosecutor in Franklin County, and look forward to working with all of you, and we appreciate the hospitality that your school has shown us. Thank you.
My name is Nicole Daner. I'm Chief Legal Counsel for the board. I'm just going to describe to you a little bit about what the process is that you'll see today so you have an understanding of what's going on. And then we've built into the agenda an opportunity for questions and answers with the board members at the end of the day. So feel free to make a note of anything that sparks your interest, and we can certainly address those questions that you might have at the end. This morning, what you're going to see first on the agenda are what we call 119 hearings. They're administrative hearings, and we just refer to them as 119 because that's where they are found in the revised code, which is where all of the laws and rules are for Ohio. So the administrative hearing process is something that is afforded to anyone who has a license in the state of Ohio, whether it's a physician, a nurse, anyone who gets afforded a license. If there should be some kind of disciplinary action against that license, they are given an opportunity to present their side of the situation before the board, or typically it is a hearing officer. In a lot of other settings, our board has an interest in hearing every case, and so our board members assemble for every hearing and make decisions on what should happen to a particular license. So what you're about to see will be a proposal for disciplinary action against currently active licensed pharmacists. You will hear a presentation by the state of Ohio. We are represented by the Office of the Ohio Attorney General. And so you will be hearing a question and answer. Ms. Yvonne Turtel is the Assistant Attorney General assigned to the board. She will present the case by calling witnesses, much like you might see in a court case. Criminal case or civil case, she will have an opportunity to call witnesses, present evidence, and then submit that information into evidence for the board's consideration. At the conclusion, typically we would have what's called a respondent, or the person that is the licensee would have their turn to make a presentation to the board. The two cases you're going to hear today, the respondents, the licensees, did not request a hearing, did not request to come before the board to present any information. Typically, if they had, they would be sitting here and also have the opportunity to call witnesses, present evidence, or any mitigation that may lead to an explanation of the events that are before the board. So we are required by law to serve the licensees with a notice, and we have certain ways to get that service achieved. We did make sure that the individuals in this case were served properly with the requirements of the law, and they just chose not to request a hearing. So the board will be making a decision based on the information you'll hear in the state's case today. And if any other mitigating evidence comes out, it will be through the testimony and the documents that are entered into evidence. So that's just a little bit about the hearing process. We will be doing 2 hearings first, and then we'll go into board business, which will be a series of reports by board staff to the board members. And then also we'll have some discussion on rules, resolution, pending legislation, things like that. So that'll be the flow for today. And we're going to, I'll turn it back over to the president, and Ms. Marshall will kick off the process for the administrative hearings.
Thank you very much. All right, Mr. Teller, are we all set?
Hello? Now I'm ready.
Perfect. All right, wonderful. Thank you. The State of Ohio Board of Pharmacy will now consider the matter of Brian Dvorak in accordance with Chapters 119 and 4729 of the Ohio Revised Code. It is Tuesday, October 10th, 2017 at 10:14 a.m. Let the record show that Brian Dvorak did not request a hearing pursuant to the Notice of Opportunity for a Hearing dated March 14th, 2017. This matter will proceed under the precedent of the 10th District Court of Appeals case Goldman versus State Medical Board of Ohio. As such, this proceeding will not consist of a full adversarial and evidentiary proceeding, but a reliably evidentiary review. While the respondent may attend the hearing due to the public nature, they cannot testify, call witnesses, or present witnesses. The respondent has no right to make any argument in this proceeding. I am Megan E. Marshall, President of the Board, and present are the following members of the Board: Richard J. Newland, Curtis L. Passafume, Jennifer M. Rudell, Fred M. Weaver, Sean C. Wilt, and Kylie S. Yarsh. Also present are the Board's Executive Director, Stephen W. Shearholt, the Board's Chief Legal Counsel, Nicole M. Daner, and the Assistant Attorney General, Yvonne Turtel. Ms. Turtel, are there any preliminary matters or motions for the Board to consider?
We have no motions preliminarily.
And do you have an opening statement at this time?
Just briefly, if you don't mind.
Absolutely.
My name is Yvonne Turtel. I'm now your AAG. I work with the Ohio Attorney General's office, and I've been assigned to you as a client. It's very nice to see all of you today on my first go-round with you. In this particular case, we have a gentleman who, Brian Dvorak, I'm not sure if I'm pronouncing that correctly, but I'm going to go with it. It's basically an error in dispensing case, mislabeling kind of case. You will see that through the testimony of Ms. Joanne Pradina. She was not the initial investigator in the case, but as happens, like I'm the first one this is my first run with you today. You had another AAG and another one before that. Things change. The original investigator in this matter is not available today, so the case was transferred or reassigned to Ms. Pradina, and she did her own review, and she's able to testify to all of the pertinent information that you would need to make a decision today. So with that, I would just ask that Ms. Pradina be sworn as a witness.
Perfect, thank you. So Ms. Pradina, please raise your right hand and repeat and attest to the following. Do you swear that the testimony you are about to give is the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Please state your name, spelling your last name, and your address for the record, please.
Joanne D. Pradina, Predina, 77 South High Street, 17th floor, Columbus, Ohio, 43215.
Thank you. Mr. Tell, please proceed.
Thank you. We'll share. Okay. Would you just tell me what it is that you do for the State Board of Pharmacy?
I'm a compliance specialist with the Ohio State Board of Pharmacy. As a specialist of the Board of Pharmacy, my duties are to conduct inspections of facilities that distribute, manufacture, store, and sell controlled substances and dangerous drugs. Additionally, specialists are responsible for enforcing and investigating drug law violations of the Ohio Revised Administrative Codes and the United States Code of Federal Regulations.
Could you just tell us briefly what your own personal background is with regard to your professional life?
I'm a compliance specialist with the board for over 25 years. I've been a registered pharmacist, a graduate of The Ohio State University for over 40 years. I've worked retail pharmacy, hospital pharmacy, home infusion, which is now called sterile compounding, and I owned my own pharmacy for about 7 years.
Would you just tell us how you came to be involved in this case?
The agent that did the original investigation is not on duty at this time and can't testify. So that case was reassigned to me for testimony today.
And what did you do in order to prepare yourself for being here today to testify?
I reviewed the case information and the findings, and I'm able to testify to everything that was in the case file.
Okay, thank you. I'd ask that you turn to what has been marked as State's Exhibit number 1. Are you there?
Yes,
You're there.
ma'am.
Okay. Could you please identify that document for me?
State's Exhibit 1 is the notice of opportunity for hearing that was given to Brian Dvorak on March 14th, 2017. It states the allegations, and service was provided and signed for as shown on the return for service card. So he did receive the citation.
So there is a copy of the return of service card in Exhibit 1, correct?
Yes, ma'am.
Okay. And could you just briefly tell us, I know we're not asking for a legal review, but what is your understanding of what we've charged him with in this notice?
On August 1st, 2015, Mr. Dvorak misfilled a prescription. The prescription was written for 120 tablets of oxycodone acetaminophen, 10 milligram, 325, and it was filled with 120 tablets of hydrocodone acetaminophen, 10, 325. The patient received the medication and looked at it when he got home, and within 10 minutes returned to the pharmacy to say that he didn't think he had the right medication because it didn't look like his past medication. Mr. Dvorak checked the bottle that was on the counter and said, yes, it's the correct medication. He did not check that against the original prescription or the prescription label. So not only was it filled incorrectly, but the second time he had a chance to catch it, he didn't. The unusual thing in this case is there was no patient harm, physical harm for this error. The patient was in a program for pain management, and about 40-some days after he received the prescription, on September 18th, he went to his doctor's office appointment, and a urine sample was taken, and he tested positive for hydrocodone. The script was written for a 30-day supply, although it was a PRN prescription, and when he tested positive for hydrocodone, they kicked him out of the pain management program. So he filed a complaint because he was kicked out of his pain management program because of what he thinks is the error in dispensing. There were some extenuating circumstances along with that, though, that caused him to be released.
So for the purposes of our exhibit identification, could you turn to State's Exhibit 2? Could you tell me what that is?
State's Exhibit 2 is the credential view screen that comes from the State of Ohio e-license view. It shows that Brian Dvorak was had an active license, and the jurisdiction for the citation was in place at the time the citation was issued.
Okay. Now there's some items that have been marked off, old school style with a Sharpie near the top center of the page, correct?
Yes.
Okay, did you do that?
No, Mr. Tell, you told me that you did that to remove the personally identifying information that was on this document.
Such as date of birth and social security number, correct?
Yes.
Okay, thank you. Let's turn to State's Exhibit 3. Could you tell me what that is?
State's Exhibit 3 is the second page of actually one document. State's Exhibit 4 is the first page, and State's Exhibit 3 is the second page. This is the incident report that the agent picked up when he did his investigation. This is the internal incident report that was filed when the incident was reported. And
but for the purposes of the way I've marked it, State's Exhibit 3 is actually a statement, correct?
State's Exhibit 3 became the exhibit after Agent Whitney went in and notarized the exhibit. There's an additional inset in there from July of 2016 that was inserted to the original.
So what does it reflect?
This reflects what Mr. Dvorak said happened during the process of the error.
I don't need you to read it because I know everybody can read it, but can you summarize for me what his statement was and what his position was with regard to what had happened?
He checked the prescription and checked it incorrectly. The prescription was filled with hydrocodone in the container. It was labeled correctly and billed correctly, but what he did is he just missed the final check.
Let's go now to what has been marked by us as State's Exhibit 4. I know that you were saying that this is all part of one document, but for the purposes of this hearing, State's Exhibit 4, what is that?
State's Exhibit 4 is the first page of the incident report form.
And what does it tell us?
It tells you that when the patient came in, a pharmacist filled out the internal incident report form, and then it gives the detail of what happened and who was on duty at the time of the error.
Okay. Now, on the back of that incident report form, or, well, the next page, sorry, explain to me what we're looking at with this kind of dark, I just want to describe it for the record, dark colored photocopy that says null and void, and then there's a sticker. What are we looking at?
This is a photocopy of the original prescription, and it's on tamper-evident paper, which is why it came out saying null and void And the sticker in the upper right-hand corner is the back tag that we put on when we dispense a prescription. And above that, you can see a little bit of the pharmacist's initials that's in handwriting.
Were we able to actually obtain a copy, or excuse me, were we able to obtain the prescription itself?
Yes, we were.
Okay. Let me go out of order a little bit, and let me have you look at what's been marked as States Exhibit 5. Tell me what that is.
This is the original prescription for the prescription from Brewster Pharmacy.
And can you testify from that document directly?
Yes.
Okay. What is significant about the prescription from your point of view as an investigative entity?
The prescription was written in June regarding this case. It was a do not dispense until 8/1/15. It's signed and in ink with positive identification by Mr. Dvorak on 8/1/2015.
At this point, I'd like to ask if the board members would like to see this exhibit at this point, or if you would like to wait until the close of the case. We can circulate it for your review then or now. Whatever you would like is perfectly fine.
I think at the time that we're going to be reviewing the exhibits, if you'd like to approach, feel free. I think at that time. Board members?
When you admit? When I move to admit?
When we move to admit,
okay.
please. That'd be great.
Thank you. All right. Is there anything else that we need to discuss about that particular document, Ms. Perdino?
No.
Okay. Let's go forward then with the rest of part of the packet of States Exhibit 4. There were a couple more pages in States Exhibit 4, which was the incident report, correct?
Yes.
And what are those?
These are copies of the patient profile.
And what does that signify?
It shows what medication the patient was on and shows the dates that they were filled.
Now, in this case, I know you came on to it after the fact, but you did a thorough review, correct?
Yes.
Did you inquire or investigate or whatever it is that you guys do internally to see if there's been prior discipline against this particular person?
Yes, I did.
Okay, and could you tell us what your findings were?
There was a 2014 case for the same pharmacist, and it was a similar error. He had dispensed, the prescription was written for trazodone 50 milligrams and tramadol 50 milligrams was dispensed. The patient took one tablet and claimed that she was ill from that one tablet, came back the next day, and he made the correction to the error. On August 19th, 2016, that case was settled for a $500 fine and completion of continuing education units.
And did you verify that those parameters have been fulfilled?
Yes, they have all been fulfilled.
And how did you verify that? Did you consult with the staff of the ward?
I consulted, yes, and found out that it was all completed.
I have no further questions. If the board members care to inquire.
Ms. Turtell, are you going to be moving these exhibits into evidence at this time then?
Well, pending any questions, I can do it now, or I can do it if the board members have questions. I'd be happy to move them into admission, States Exhibits 1 through 5, although I have not yet shown the board members that you have 1 through 4 before you, but you have not seen 5. So would you like me to circulate that now?
Yes, please. We'll go ahead and we'll move these into the record, and then we're going to take a few moments at a brief recess at this time for the board members to review the exhibits.
So, for my clarification, did you admit them?
Yes.
Once you review the prescription, then
Yes,
you'll
please.
do a separate admission?
Yes, please.
Okay, thank you.
Excellent. Thank you. We'll take a brief recess at this moment. We'll take a brief recess at this moment, off the record.
It's just a little awkward having to go out, you know, give them that evidence. I scanned it into the file in case somebody wanted it there. I thought they would send Rachel down to pick it up. For you just to come get it.
I don't know what they do.
About the markings on the page, or says somebody told me.
Ms. Turtell?
Okay, so you told her.
Let me ask them if they want.
She's going to need a copy of this one then, huh? Because we can't give her the original.
Usually the court reporter doesn't take it.
Oh, okay.
But I
Yeah.
don't know how they do it.
Okay, Rachel knows. That went well. That was the easy one.
Yeah, that's why I want to get it out of the way.
All right, about that. We will go back on the record. The time is now 10:30. Mr. Tell, would you like to continue your questioning of the witness now that the board members have reviewed the documents?
No, I believe I have no further questions at this time. My motion to admit the exhibits into the record is pending your review of them. So I would just reiterate that, ask that you make a ruling to admit them. And then, of course, if the board members, I'm not quite sure if you all have questions or not, but I know that you generally do, so.
Absolutely. Board members, do you have any questions for this witness right now?
I have one question for Ms. Perdina. I know you're new to the case, so I'll give you that. Curious if you're in the investigation of the case file from the previous administrative hearing, if you were able to find a record of a incident report form from the pharmacy from that incident. Does that exist as part of our records? Do you know?
I did not look for that.
Okay, thank you.
Any additional questions, board members?
Madam President?
Mr. Wilk.
Ms. Perdina, I have two questions for you. The first is, were these errors made because he was not utilizing his company's safety mechanisms, or was he following proper workflow and policies and procedures?
I have no knowledge of that because I was not the investigator on that.
Okay, thank you. And I have one more question you may not know the answer to, but in speaking of patient harm, you mentioned the patient actually suffered no harm, but he was obviously discharged from his physician. Mm-hmm. Are we aware, was the patient able to find treatment to take care of his medical condition?
According to the report, he did. He also had additional prescriptions that were post-dated, so he still had medication. That one you saw was issued in June with a do not fill until August. He had a prescription filled at a different pharmacy during the same time period. So he had a mechanism for 8 physicians and 4 pharmacies that he was going to.
Thank you.
Mr. Weaver.
On Exhibit 3, under where it says Thursday, 10/22/15, the second paragraph that begins with, "I called Suma, pain specialist." It says, Carol also made the comment that there were other reasons he was discharged as a patient from the pain management clinic. Are we aware of what that might be inferring?
Part of it was what I alluded to just earlier, that he had multiple physicians and multiple pharmacies.
Okay.
And because of the timing on this, that medication was expected to be used in 30 days, which is why he kept getting 30-day scripts.
Right.
18 days after it should have been used up, he's still being tested positive for hydrocodone, and the script filled at 18 days earlier at Discount Drug Mart was filled for oxycodone.
Was it oxycodone?
So where is he getting his hydrocodone was the question.
Did we have ORS reports or any information on his filling history back then?
8 pharmacies and 4 physicians, and every month, but not necessarily the same pharmacy.
Okay, thank you.
Anything additional, board members? Mr. Tell, is there anything further?
I just have a couple of additional items. Was there an actual, did you rule on the admission of the exhibits into evidence yet?
Yes, we did.
Okay, so states exhibits 1 through 5 have been admitted, correct?
Mm-hmm. Correct.
This is a little bit different procedure than I know what you all are used to, but in consultation with my office, I am going to now ask that the board consider sealing a list of exhibits, and I will give you the numbers. The reason for sealing these documents from public view is that they contain protected medical information and health history and health information. So while we don't expect a case such as this to go up on appeal, you don't ever know. And with the board's, if the board were to grant this order, which I would encourage you to do, we could then transmit the record sealed to the court, should it have to go that way. And there would be, if the court ordered it open, it would be on the court as to, they would be the entity letting that information out and not the board. If there are any questions, I can certainly address those, but I think it appears you understand what I'm asking for.
Absolutely. So we'll go ahead and accept that request.
Okay, and so what I would ask are States Exhibits 3, 4, 6, 7, 8, 9, 10, and 11, because all of those documents or exhibits have protected health information in them. Patient name, prescriptions, all of that.
Are you referring to pages or exhibits? Because I only have exhibits 1 through 5.
I'm sorry. I'm ahead of myself. I flipped the page already. You caught me. Exhibits 3, 4, and 5, because we added that at the last minute.
Absolutely.
Thank you. I'm
Yeah.
sorry.
No, absolutely. I think at this time we'll accept the redaction of the personal information and seal the records as requested, and it'll be granted at the time that we are putting forth our board order at that time.
3, 4, and 5.
3, 4, and 5. Absolutely. Thank you very much. Anything additional, Mr. Tell?
I have nothing further, just request the board make its deliberation when it goes into quasi-judicial.
Perfect. Thank you very much. This witness is now excused at this time. Are there any additional witnesses that you would like to?
Not for this matter.
All right, perfect. So for the record, I'd like to verify that exhibits 1 through 5 have been entered into evidence in this case. Mr. Tell, would you like to make a closing statement at this time?
I would be happy to waive. I believe the board has all the information that it needs to make a determination.
Perfect. Thank you, Mr. Tell. This case is now closed, and the board will consider the disposition of this case and notify Mr. Dvorak by mail. Written notification will be issued and will become effective the date of mailing unless otherwise noted on the record. We're now off the record. So at this time, we would typically go into a quasi-judicial review and actually be excused to deliberate this case to moving forward. But due to the fact that your time is precious and we'd like to keep things moving, and there is no, we don't have anybody on the other side of our cases at this moment, we're going to move right into our next case at this time. If anyone, is everyone good to move forward? I'm getting my head nods and thumbs up from my board members at this time. Mr. Teller, are you ready as well?
Yes, I am. Thank you.
All right, let me get us situated then. Rachel, you good? Okay, perfect. All right. We are back on the record. The State of Ohio Board of Pharmacy will now consider the matter of Larry Selby, in the accordance with chapters 119 and 4729 of the Ohio Revised Code. Today is Tuesday, October 10th, 2017 at 10:37 a.m. Let the record show that Larry Selby did not request a hearing pursuant to the Notice of Opportunity for Hearing dated March 15th, 2017. This matter will proceed under the precedent of the 10th District Court of Appeals case Goldman versus State Medical Board of Ohio. As such, this proceeding will not consist of a full adversarial and evidentiary proceeding, but a reliable evidentiary review. While the respondent may attend the hearing due to its public nature, they cannot testify, call witnesses, or present witnesses at this time. The respondent has no right to make any argument in this proceeding. I am Megan E. Marshall, President of the Board. Present are the following members of the Board: Richard J. Newland, Curtis L. Passafume, Jennifer M. Rudell, Fred M. Weaver, Sean C. Wilt, and Kylie S. Yarsh. Also present are the Board's Executive Director, Stephen W. Shearholt, the Board's Chief Legal Counsel, Nicole M. Daner, and the Assistant Attorney General, Yvonne Trutell. Ms. Trutell, are there any preliminary matters or motions for the Board to consider at this time?
Not on this matter. Thank you.
Thank you. Do you wish to present an opening statement at this time?
Again, I'll be very brief. This case is very similar to the one that we just heard, an error in dispensing case. We also have Ms. Joanne Perdino as well as the investigator on this matter. This is a bit different in that she had this case from the beginning and did not, get subbed in at the end of the case, so she's been with it from the very beginning. And she will present the testimony and evidence to the board today.
Perfect. Please proceed with your case then.
And I would ask that Ms. Perdina be sworn as a witness on this matter.
Ms. Perdina, please raise your right hand. Do you solemnly swear to tell the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name, spelling your last name, and your address for the record, please.
Joanne D. Perdina, P-R-E-D-I-N-A, 77 South High Street, 17th floor, Columbus, Ohio, 43215.
Thank you. Mr. Tell, please proceed.
Thank you. Good morning again.
Morning.
Okay. We're going to repeat some things because we have a new case before us. So would you please go ahead and tell us what you do, even though we all already heard what you did on the other case. But tell us what you do for the Board of Pharmacy.
As a specialist of the Board of Pharmacy, my duties are to conduct inspections of facilities that distribute, manufacture, store, and sell controlled substances and dangerous drugs. Additionally, specialists are responsible for enforcing and investigating drug law violations of the Ohio Revised and Administrative Codes and the United States Code of Federal Regulations.
And would you just tell us a bit about your background, professionally?
I've been a registered pharmacist for over 40 years, a graduate of The Ohio State University. I've worked for the State of Ohio Board of Pharmacy for over 25 years as a compliance specialist. My background is in retail pharmacy, hospital, sterile compounding, and I owned my own store for about 7 years.
Just tell us how you came to be involved in this case.
This case was assigned to me through the normal channels from compliance and enforcement. The patient and his wife filed a complaint, and the investigation began.
Let's go ahead and just identify our exhibits, and we'll walk through the case that way, okay? Go to State's Exhibit 1 and tell us what that is.
State's Exhibit 1 is the Notice of Opportunity for Hearing sent to Larry Selby on March 15, 2017. It states the allegations and the potential violations of law.
And again, just give us a summary of what we've charged him with today.
On April 18, 2015, Mr. Selby received a prescription for 100 tablets of oxycodone 5 milligram immediate release tablets, and that prescription was dispensed with oxycodone 30 milligram immediate release tablets.
And did we obtain proper service on this notice of opportunity for hearing?
Yes, we did. The return of service card is enclosed as evidence.
Okay. And that's also part of State's Exhibit 1, correct?
Yes.
Okay. All right, let's go to State's Exhibit 2, and please tell me what that is.
State's Exhibit 2 is the credential view screen from the Ohio e-license system, and it shows that Mr. Selby was licensed and we had jurisdiction at the time of the citation, and at the time of the error, he was licensed.
And there are some, again, lovely crossed out Sharpie areas up top on our original copy, or our hard copies today, correct?
Yes.
And again, did you do that?
No, Mr. Tell, you did that prior to me receiving the evidence.
And did I share with you why that was?
It's personally identifying information, and it should not be included in this piece of evidence.
Would that be date of birth and social security number identifiers?
Yes.
Okay. Let's go to State's Exhibit 3, and just tell me what that is.
State's Exhibit 3 is the copy of the original prescription for the patient, and it says it's for oxycodone immediate release 5 milligram tablets. The directions are 1 to 2 tablets by mouth every 3 hours is needed. It's clearly written, and the sticker in the lower right-hand corner shows that the right medication was entered in data to be pulled from the shelf.
Now, there's another page. Can we turn the page? I think there's another page to State's Exhibit 3.
State's Exhibit 3, yes, your page number 8 is just the back of the prescription. That's why it looks like a blank page. It has my initials on it for receipt. And then the next is a copy of the label that would have been generated for the prescription. So the top part is what would have been on the prescription vial, and then the rest is stickers and billing information for the bag.
Okay. Let's go to State's Exhibit 4. What is that?
State's Exhibit 4 are photos that were provided to me by the family of the medication. And the photo on the left is the one that has the actual label on it that says oxycodone 5. And you can see the back side of that bottle. It's a commercially available stock bottle. it says 30 milligrams, and the 30 milligram sealed stock bottle was dispensed.
What is State's Exhibit 5?
State's Exhibit 5 is Larry Selby's statement.
Did you take that?
I took that statement on October 19th, 2015, in an interview with Mr. Selby, where he explained to me the circumstances of how that error occurred.
Can you just briefly summarize what your findings were from that interview with him?
The prescription data entry was correct, the label was generated correctly, and moving down the line, everything was going as should. In this facility, they scan the commercial container, if they're using it, and they scan the prescription label, and it matched. So there was no rejection here for this prescription. But during processing, the processing got held up due to some insurance information that they needed to make the billing go through. So actually, the workflow process took a stop. At the same time, and I did the record check, there were 2 other oxycodone prescriptions that were very close to being processed, and they separate their controlled substance out for processing. So what is believed to have happened is that when that workflow stopped, the label was there, checked, the vial was checked correctly, the 5 milligram commercial, because it all matched up, and there was no stop. But what happened was when Mr. Selby, he puts the labels on himself, when he grabbed the bottle, he grabbed the very similar size look-alike container of the 30 milligrams and put that label on there, and it went out the door to the patient. So the prescription is actually misbranded.
Let's turn to State's Exhibit 6. And what is this?
This is the confidential pharmacy misfill report, which is also known as the incident report. This was taken the next day. This prescription was consumed for 1 day. And the patient's wife came in with a complaint. The prescription complaint was not taken by Mr. Selby. It was taken by a different pharmacist. And when I talked to the patient and his wife, the reason they filed the complaint was not so much the error, but it was because of how they were treated by the person taking the complaint. That she said, well, it was our part-time floater pharmacist, and sort of didn't give it the respect that the family thought it should have for the type of error.
So they filed the complaint, and what is State's Exhibit 7?
State's Exhibit 7 is pages of, 2 pages for DUR to show that there was nothing here that would have triggered a DUR review. The dose, based on the way it was written, was appropriate, and so there was no DUR trigger to stop anything from being dispensed.
And what is State's Exhibit 8?
State's Exhibit 8 is one of the many dispensing screens, but it is a screen that shows pharmacist Selby dispensed it, the right drug was chosen, and all that upfront process was correct.
Okay. What about State's Exhibit 9?
State's Exhibit 9 is another screenshot that can come out of the Pioneer Pharmacy system. It shows, again, a copy of the prescription on the lower half, and the upper half shows that it was picked up. You'll see it says counseling refused, but that's appropriate in this case because the patient was not standing there to pick up the prescription, and they can't counsel the wife.
So the wife was the one who picked it up, correct?
Yes.
Okay. Then let's go to State's Exhibit, are we at 9 or 10?
Second page of 9.
Second page of 9? Okay, you're not finished with 9. Go ahead, tell us about the second page of 9.
Second page of 9 is the signature log from the point of sale system. In this pharmacy, the point of sale system won't catch any type of error like this, but it does show that it went to the right patient. The time on here is April 18th at 2:49 p.m., which will become important when I talk about the actual error.
So what is State's Exhibit 10?
State's Exhibit 10 is the patient profile.
And what does that show?
It shows the medications the patient has been on over time, and the date and fill of this particular prescription went through correctly as oxycodone 5.
Anything more in State's Exhibit 10?
No, those are just continued pieces of patient profile.
Okay. State's Exhibit 11, what is that?
State's Exhibit 11 is another workflow screen that shows the time that the prescription was completed and it was picked up at the point of sale, who did the fill and check. The handwriting to the right was not mine. That's filled in by the staff at the store, so you can tell exactly what happened. So it does show Mr. Selby was the one who did the final dispensing and put it in the bag and sent it out the door.
And for purposes of reviewing the case, you again would have looked for any previous discipline, correct?
Yes.
And what were your findings with this particular licensee?
I could find no previous on Mr. Selby.
And we don't have any originals here today. What we're using as originals are all copies, correct?
These are true and accurate copies, yes.
True and accurate, and represent the records of the board, correct?
Yes.
Do you have anything else that we've not gone over? I think we've covered everything.
I need to talk about the error.
Oh, well, please do.
If you look at the Exhibit 6, the wife brought back the prescription because her husband took, there's a verbal piece to this that's missing from the original directions. The patient was told to start with 3 tablets. So 3 5-milligram tablets, it's not in the SIG, it's not on the prescription. 3 5-milligram tablets, he had a total knee replacement and was in the hospital for several days. So when he came home, he did take his 3 tablets at about 2:50, 3 o'clock on the day of the error. When he did that, he consumed 6 times the dose of oxycodone. So instead of taking 15 milligrams, he took 90 milligrams of dose. That started a downward cycle. His breathing was labored. He was not opiate naive because he had it in the hospital. So he was having trouble breathing. He was dizzy. He was just rottenly sick. Throughout the next 24 hours, 25 hours, if you look at the time, that's why I included all these other documents, he's consumed 11 tablets. I don't know for sure if he took them 1 or 2 or how he took them, but when you look at the dose that he took 330 milligrams of oxycodone in 24 hours.
So your testimony is, correct me if I'm wrong, he clearly suffered adverse effects from this error in dispensing, correct?
He did. He did. Overall, he took 3.5 times the dose of oxycodone that he should have in that 24-hour period.
Would you classify that as patient harm?
That's patient harm, yes it is. Yes it is. So the issue here is that the prescription came back, the pharmacist recognized the error, and they made the exchange on the medications. And the patient is fine, it was temporary harm, but it was definitely patient harm.
I believe at this point, if you'd like me to move to admit the exhibits into the record, I will do that. State's exhibits, this time 1 through 11, we would move to be entered into evidence. And then, of course, whatever period of review you need or the board's questions, I'm sure.
Perfect.
Coming.
Thank you. Thank you. We'll now move the state's exhibits 1 through 11 are admitted into evidence. At this time, I'd like to recess for a brief few moments, excuse me, in order for the board to review the exhibits at this time. We will now go back on the record. It is 10:54. Mr. Tell, were there any additional questions or proceed further with questioning for Ms. Pradina?
No, just proceed with whatever the board's inquiries might be.
Perfect, thank you. Board members, what questions do you have for this witness, please?
Madam President, I have a question.
Mr. Wilt?
Ms. Pradina, you were describing the workflow error and how the proper scan occurred to validate it was correct. And you mentioned that there was another patient that should have gotten 30 milligrams that was on the counter. Are we aware, did that patient's prescription get filled correctly, or was that also misfilled?
No, that was part of my investigation. It was filled correctly. Everything around there was filled correctly.
Thank you.
Board members, any additional questions at this time? At this time, if there's no further questions, or if you don't have anything further for this witness?
I have nothing further for this witness, and I have no further witnesses.
All right, perfect. Well then, at this time, for the record, I'd like to verify that the exhibits have been entered into evidence at this time. States Exhibits 1 through 11.
May I make a motion for
Yes,
seal?
please.
This is the one with a lot of documents that
Perfect.
I had done earlier. I'll say it a couple of different ways. Basically, States Exhibits 3 through 11, with the exception of States Exhibit 5, I'm asking to be sealed because of protected health information contained therein. Numerically, it would be 3, 4, 6, 7, 8, 9, 10, and 11. States Exhibit 5 is Ms. Pradina's interview statement that she took, and she was very careful and cautious not to include that, and rightly so. So there's no need for a seal on States Exhibit 5.
All right, perfect. So at this time, we'll go ahead and accept that motion, and it will be granted at the time of the board order.
Thank you.
Mr. Tell, would you like to make a closing statement at this time?
Again, way of closing, I believe the board has sufficient information to make its determination.
Perfect, thank you very much. So this case is now closed. The board will consider the disposition of this case and notify Mr. Selby by mail. Written notification will be issued and will become effective the date of mailing unless otherwise noted on the record. Do I have a motion to recess for the deliberation of the quasi-judicial matter in accordance with Chapter 119 of the Ohio Revised Code and Ohio Case Precedent? And we'll be reviewing Mr. Dvorak's case as well at this time.
Madam President, I'll make that motion.
Thank you, Ms. Yarsh. Is there a second to that motion?
I'll second.
Mr. Weaver? Mr. Newland? Mr. Passafume?
Yes.
Ms. Rudell?
Yes.
Mr. Weaver? Mr. Wilt?
Yes.
Ms. Yarsh?
Yes.
At this time, we are off the record. Perfect, thank you. So we are going to, so you guys don't have to get up and leave while we deliberate, we are actually going to move to the room, and I can see we're being motioned that way. So you guys sit tight. We're going to go deliberate and come back after and present our stance on the two cases. So sit tight. Thank you, guys. All right, the time is now 11:17, and we're back on the record in the matter of Brian Dvorak. Do I have a motion as to the findings of fact, please?
Madam President,
Ms. Yarsh?
I would like to make a motion as the board's finding of fact in the case of Brian Dvorak, paragraph 1, as listed in the notice for opportunity for hearing letter.
Thank you. Is there a second to that motion?
Madam President, I'll second that motion.
Thank you, Mr. Passafume. Any discussion? All in favor? How many do we have? 6. All opposed? 0. Do I have a motion as to the conclusions of law?
Madam President,
Ms. Yarsh?
I would like to make a motion that the board finds as its conclusions of law in the matter of Brian Dvorak, paragraphs 1 through 3 inclusive, as listed in the notice of opportunity for hearing.
Do I have a second to that motion?
Madam President, I'll second that motion.
Mr. Passafume. Is there any discussion? All in favor? 6. All opposed? 0. And do I have a motion as to the decision of the board in the matter of Brian Dvorak?
Madam President, I have a recommendation for the decision of the board.
Thank you, Mr. Wilt.
I move we assess a $800 fine and that Mr. Dvorak has to complete 12 continuing education modules on patient safety as set forth in Category 5 of ACPE standards, which is med errors and patient safety. These are not to count to relicensure, and he must complete within 90 days of issue of the order.
Thank you, Mr. Wilt. Is there a second to that motion?
Madam President, I'd like to second, please.
Thank you, Mr. Weaver. Is there any discussion? All in favor of that motion? 6. Nothing. That concludes the matter of Mr. Brian Dvorak. And we are back on the record at 11:19 in the matter of Larry Selby. Do I have a motion as to the findings of fact?
Madam President, I'll make a motion for findings of fact, being paragraphs 1 and 2.
Thank you, Mr. Weaver. Is there a second to that motion?
Madam President, I'll second that motion.
Thank you, Ms. Yarsh. Is there any discussion to the motion? All in favor? 6, nothing. Do I have a motion for the conclusions of law?
Madam President, I have a motion for the conclusions of law.
Thank you, Mr. Wilt.
I move we find items 1, 2, and 3 inclusive as found in the notice of opportunity hearing for Larry Selby.
Is there a second to that motion?
I would like to second that, Madam President.
Thank you, Mr. Weaver. Is there any discussion? All in favor? 6, nothing. Thank you. And do I have a motion as to the decision of the board, please?
Madam President, I would move that the board assess Mr. Selby an $800 fine, that we assign 6 hours of continuing education in Category 5 according to ACPE standards and patient safety and medication errors, not to count to his licensure, to his relicensure, and that he would complete the 6 hours of CE within 90 days of issuance of this board order.
Thank you, Mr. Passafume. Is there a second to the decision, to that motion?
Madam President, I'll second that.
Thank you, Ms. Yarsh. Is there any discussion? All in favor of the motion? 6, 0. That concludes the matter of Larry Selby. Thank you very much. So at this time, we have finished with our cases. Since it's only 11:20 and I understand that there's going to be, you guys may not be joining us this afternoon, we wanted to take this opportunity to open up the floor for questions from you guys. If you have any questions that you would like to ask the board regarding the cases. We can't speak on specifics or how we deliberated or how we came to said conclusions, but if there are anything that is on the tip of your tongue, burning questions that you would love to ask, we will happily take those at this time. Or if everyone is in the sugar lull of before lunchtime, Christmas. I'm on Christmas time apparently. Strike that. I definitely need a Snickers.
Hi, Andrew Vistas on faculty here at Findlay. At the beginning of this, you mentioned that the respondents were given the opportunity to appear, but later in the session you said that they were not allowed to present evidence. Can you explain that a bit?
I can actually speak to that. So the legal process for these administrative hearings, if you do not request a hearing within 30 days, it's a very strict timeline that precludes you from then from bringing any evidence at the hearing. The board will, in exceptional circumstance, if you miss that deadline for some reason, will, in exceptional circumstance, grant the hearing. But typically, if you miss your 30-day deadline, then you don't get to, you can come and watch, but you don't have an opportunity to speak. It's a good question.
Absolutely. Good question.
I know there are folks upstairs. I can come up if anybody needs the mic up there.
How about you guys up there? I will zero in on you. I see earphones coming out of ears. Any other questions? It's okay. Oh, there we go.
Neither of the respondents were here today. Typically, do respondents come for a hearing, or do they usually not attend?
And I couldn't give you an exact number. What the question was, if everyone, is typically we do have people on the other side of the table. It's not just us always presenting case and evidence to the board members to hear and then us decide. Typically we do when we do have hearings. I would say, Nicole, do you think it's about 50-50 that people do request a hearing? Do we have a number on that?
Probably 60-40. It kind of depends. A lot of cases do settle prior to actually coming before the board, so they may request a hearing, but it usually gets set several months out. And during that time frame, they may approach us with an offer of settlement, and then the board will accept, reject, or counter. So the cases that are here and that you heard today either were not offered a settlement, did not contact us for settlement, but probably of the cases that go to hearing, it's probably 60-40 in terms of those that actually show up for the hearing and those that do not.
Yep, so typically during these cases, after Ms. Turtel would present her case and we would review the evidence, she would have her witnesses and we would ask questions. At that point, there would typically be another lawyer and the respondent sitting on this side, then presenting their side of the story and their case and their evidence. So it's hard to show that type of these cases to you when there's somebody not actually sitting in the seat to be able to so to speak defend themselves or to give their side of the story. So it was difficult to show that today, but yeah, about 60-40 as Ms. Daner had already stated. Board members, did you have anything added to that? No?
Can a pharmacist appeal the decision to the board? Is my first question. And my second question is if a pharmacist does not meet the adjudication that has been decided in regards to both continuing education and also the monetary fine, what is the next course of action for the board?
Perfect. Nicole, did you want to? We'll just keep it in her ball.
So with respect to what is the next course of action, yes, they can appeal. There's a process whereby they would petition and would go before the Common Pleas Court. Typically, they're heard in Franklin County, and it works its way up through the appellate process there. So once the board issues its order, and that generally takes about 30 days because it gets ratified at the next meeting, unless otherwise effective upon issuance when it goes out in the mail, they'll have approximately 15 days is the time frame to file an appeal, and then it works its way through the appellate process. If the individual or company should fail to meet whatever the terms were in the board's order, or even in the terms of a settlement agreement, if they failed to live up to their terms that they had entered into, that becomes a violation of the board's order, and then the board could take additional action and additional potential disciplinary leading up to and including revocation of the license in extreme circumstance.
If you guys have any questions for us as board members as well, I would like to just throw a question out to our board members. We typically, whenever we're doing these type of road shows, students will actually wonder how we actually got on the board. So I'm going to throw this over to you. How about Kylie? You made eye contact with me. How do board members actually become board members?
So speaking from solely from my experience, we are appointed by and responsible to the governor. So each one of us serves typically a 4-year term. So we apply for that through the Office of Boards and Commissions, and then through each state professional association. They also what do I want to say, ask for folks who might be interested in serving on the board, and then they also submit those names to the governor's office. And then from there, typically there's a small interview process where you meet with the director of boards and commissions and along with whoever else was selected, and then you find out whether or not you were selected for that. And then to get reappointed, the same process, you would also then submit an application for reappointment, and then you would be notified by the governor's office if you were selected for that position. So I do want to reiterate Ms. Marshall's point. Please ask us whatever questions you may have. We're not the big bad wolf, we don't bite. We want to make sure that you understand the process and what we're here to do, and what our roles and responsibilities are for ensuring the safety of the citizens of the state of Ohio. Yeah, go ahead. Yes. So each one of us is a pharmacist. Mr. Monet, who's not here, is also an attorney, but that would be the anomaly to the group. We are fortunate enough to have attorneys in our office who are able to guide us through the process of handling that, because certainly none of us around the table are legal experts, and I'm sure Nicole and our fellow attorneys would agree with that. Sometimes we don't really, they guide us through whatever we need to know.
I think that's another good point, and I'll let you speak to Mr. Pasfium, is people ask if we have to pass a test on law. And a lot of times, so I'm sure this has happened to a lot of board members and previous board members, is, oh, so did you pass a test? And everyone will come to us with questions that if we know every single point on the law. This is why we have our wonderful attorneys at the board. We don't know everything about it. We just help support the practice of pharmacy through our rules.
We also all have very different backgrounds in the practice.
Mm-hmm.
And so when we're deliberating rules, there are times where I've just learned to keep my mouth shut because it's an area of practice that I don't participate in, and I'm not a subject matter expert. And there are other times where this subject is right up my alley and I can provide use to make sure the practice of pharmacy moves forward in the state, while at the same time not becoming overly restrictive and cumbersome.
I think it's important to remember that while we have great attorneys that support us, without a doubt, some of the best I've worked with. Our role is to be, by definition, a jury of your peers, and most of your peers are not attorneys. Your peers are pharmacists. Professionally, your peers are pharmacists. So while Nicole and her team guide us around what the law actually says, it's up to the board members to interpret that law within the practice of the profession as we see it currently happening in our market space. So it's kind of nice to have that balance. We will engage in the professional conduct of and talk about that as we not only adjudicate cases, we write rules. We travel around the state and engage with our peers. But our attorneys are always right there to assure that we are following what the code and our own rules many times have given us guidance to do, because we write a lot of rules. And if you're familiar with those, you understand that there's a lot of minutia out there. So happy to have our attorneys, but we bring that professional conduct aspect into our conversations.
I know that you guys can't really give specifics, but can you kind of take us through the decision-making process? Like what specific or what major considerations do you take in? And I think we're all just kind of curious kind of how these two pharmacists, you made like the final decision.
I can speak just generically to the finding authority is fairly prescriptive, and so the notice letters that we send out, you can be penalized up to a certain amount if there is a criminal offense code that is associated with it. So if it's a misdemeanor of a certain degree, our finding authority goes to whatever that criminal offense level is. If it does not fall into the criminal code, for pharmacist violations, it's a $500 penalty. And so that's how the board can just generally make a decision. So depending on the conclusions of law that they find and the number of fines available there, generally determines how the finding authority, how the maximum finding authority. And then with respect to any other items placed on the license, that's really within the professional judgment, kind of like Mr. Pasafine was just talking about. That's where their pharmacist background comes in to determine what's appropriate under the circumstances. I don't know if the board members have anything more specific, but not to these cases, just about things that you factor in.
The citation document that the staff prepares for us will tell us very clearly what elements of the statute or rules have been potentially violated. So we start with that. That's what we look at to say, okay, here is what we believe has been violated. Then the testimony helps us, whether it be our AG and the witnesses they present with what our staff or investigative arm found, and then particularly when we do have licensees here testifying on their own behalf. It's one thing to have the documentation in front of us that will tell us a story, but there's also additional story to be told either through testimony or through our questioning of witnesses as we try to get down to the basis of what was the professional practice, what was the environment, what was your demeanor, were you under the influence, was there patient harm? There's then professional components that we will weigh in, and that's why I think it's fair to say not every case ends up with the same results. You heard it today. We had very similar cases with two different ultimately findings, not findings, two different decisions of the board. So that's our job, is to look at all the extenuating and mitigating circumstances and see what was going on at the time. But from speaking for myself, patient harm weighs heavy, and was there just disregard? I mean, you practice in the state. You need to know what the rules are. What are you obligated to do as a professional here? We expect you to understand those rules. And particularly if there are times we find blatant disregard for those rules. You acted intentionally outside of those rules. I think you might find that the board would take a pretty harsh look at that as opposed to other mitigating circumstances.
Good morning. Both of these cases had to do with oxycodone. I would assume, you won't comment specifically, that an increasing number of the cases that you rule on have to do with that. But I'm curious as to the ORS report. Is it in general a requirement as part of the submissions that you accept into evidence? I didn't hear anything about an ORS report today. It was mentioned that a particular patient happened to be opiate naive, but in general, is the ORS report something that you consider or typically require?
So there are actually some very strict requirements around the use of the ORS report, and one is that one reason you did not hear much about it is because it cannot be used as evidence in an administrative case or a civil case. There are circumstances under which it can be used for grand jury or criminal cases, and there are ways that the information from an ORS report is instrumental in being presented to the board for background on an administrative case, but the information itself, the ORS report itself, cannot be used as evidence.
Thank you for reminding me of that piece. When you talk about was the appropriate dispensing process followed, is that assured by the investigator on the case that the report was run, regardless of what the findings were? Yes, typically we, in our case investigations, our field staff is very good about ensuring that proper ORS techniques are being used and followed. So yes, that should have been and would have been likely looked at in this case. It is possible that if somebody isn't properly using ORS, that could be a case in and of itself, or it could have been added to the allegations.
Just an observation. I found it interesting that in the one case where the wife had come in and talked to the pharmacist the next day, a different pharmacist, had that pharmacist been a bit more empathetic or compassionate toward that case, maybe this wouldn't have come to this. I just found that interesting.
I'll comment to that, not from a board perspective, but from a professional side. Throughout your career, there will be times where you're going to have to be honest with a patient and say something went wrong. this didn't go right, this happened. And practicing empathy is key to that. It builds that relationship with that patient because that patient's ultimate care depends on your relationship. So whether or not it would have impacted our board decision, that's all in deliberations. But many times how you handle these, the board may have never found out about it had it actually been handled differently or appropriately in the store because it was a consumer complaint. That's speculation, I don't know that, but sometimes you're wrong and sometimes you have to be honest with a patient and accept that responsibility and follow your organization's procedures.
Hi, my name's Daniel Young. I had a couple questions for the board members. I'm more interested in the fact of how do you balance between work out there and being on the pharmacy board? And my second question is, do you feel that your colleagues treat you differently now that you're on the board? And like, do they make sure they cross their T's and dot their I's when they're around you?
Well, I think it probably depends on what work environment you're in with the balance of being on a board and your job away from the board. Some companies are more accommodating than others, but it always seems to work out. And as far as other pharmacists, yes, you do experience that. It's sort of like the HR person walking into the company break room, conversations sort of get quieter and slow down. So yeah, a little of that, which is a good thing. And we try to portray that level of professionalism when we're conducting ourselves with other pharmacists in that environment.
I think it's important too that, each board member makes their own decision about how engaging they want to be with their professional peers. But we do a lot of activity on this board that impacts the way that we work every day. And I think that part of what we have to do is to be able to take feedback from our peers, and what's happening there. What's this rule mean? What's going to there's going to be questions like that, and I think it's important that as us that represent the profession for the state of Ohio, that we at least keep an open ear to that. I don't necessarily engage in conversation or dialogue or debate about our rules, but it's always important for us to keep an open ear. We ultimately will have to make decisions, and if we do so and reach that balance between protecting our patients and allowing our profession the latitude they need to work and grow, then we've reached that sweet spot, right? And so there's always, I can speak personally that when you're not on the board, there's always a hesitancy to reach out to the board. I have a question, and the issue really is that's how we get better. That's how we make better rules, is to listen to each other and to take that feedback and work on it. I think I'm pretty confident when I say that just because you raise a question with the Board of Pharmacy does not mean we're going to send an investigator to your shop the next day. That's not the purpose of what we do here. So I think there's often a fear that I'm not going to ask the board a question because I don't want them in my shop. When in fact the reality is, by asking us those questions, giving us comments when the public comment periods are open, taking advantage of those opportunities to help shape the rules that will guide your practice. I don't think this board wants to be hugely top-down prescriptive, because we have to work with those same rules, right? There's no get-out-of-jail-free card for a board member. I mean, we still have to do our CE, file our license, our operations have to abide by the rules, so we are also definitely impacted by the rules that we ultimately promulgate. So I think dialogue, conversation with your peers is what's important, and not everybody's always comfortable with that, but in my particular position as a pharmacy executive, we're connected to lots of organizations, and so yes, people are poking on the shoulder going, hey, can I talk to you about this, that, or the other thing? That does kind of come along with the job. So I think to piggyback on Fred's point, I think if you're a smart applicant to the board, you will have checked with your employer to say, I want to really help my profession and serve on the board. Can I get some latitude from my day job in order to do this work? Because you don't want to feel you're just squeezing it in. That's not fair. That's not fair to the state. It's not fair to the staff that we work with. It's surely not fair to the profession. So I would advise you that if you have interest at some point in your career in serving on the board, just vet that out. You know, check it out and say, look, I got to be at these meetings, and there's other obligations, and we have calls, just so there's no surprises later. That would be a smart move.
I would like to add that Nicole and I, this is our day job, and 86 other people, it is our day job. The board members have other day jobs, and our goal is to support them so that, you know, maybe it's like the surgeon that shows up for surgery and everybody else has got everything in place, and that's what we strive for, is to make it as easy and as manageable as possible. In fact, we have staff right now washing their cars. Well, no, I'm just kidding about that. But it truly is to support them and help them to balance the competing interests and time restraints.
And the typical ask for a board member, we have monthly meetings. So every single month we're asked to, carve out 1 to 3 days a month to travel down to Columbus and in order to have hearings and meetings every single month. So it's a big ask if you think about how many days there is in a month that you actually are supposed to work. It's Kurt said it said it best, is we need to make sure that this is a part of our day jobs and our employers are supporting what we do every single day, because I'm not going to be expected to work 7 days in order to make up the other time that I missed from my other job. This is my job and the expectation of an employer, from my employer, and support them whenever they do have questions on rules and such. So
I'll add, in terms of questions, Mr. Passifume alluded to it, but if you call our board office right now and ask for a legal question, you'll get transferred to somebody like Ms. Perdina every day who sits by a phone. There's always somebody there to answer questions. So if you are at work tonight and you don't know the answer, you can call the board the next day and say, hey, I ran into this at work. What's the law say? And we'll have an expert there to really help guide you. It's one of the great things with our board staff is they're very available, and we won't send an investigator out because you asked a question. So
we expect you to understand the work and do it. Pharmacy is not an area where you want to have ambiguity. It's just not that space. So understand the rule, what it means, what the intent is, and if you don't, we expect you to protect your patients by finding out what the rule means and acting in their best interest. That's where we have lots of resources to help you with that. So don't have the question mark over your head. Settle it, and then do the best thing for your patient.
Hi. I would like to know, how often are there cases involving pharmacy technicians or pharmacy technicians? Also, what common situations occur with them, and if they are subject to the same penalties as maybe a pharmacist would be?
So currently in the state of Ohio, we do not regulate technicians. However, we are currently promulgating rules, and if you're here this afternoon, you'll hear some discussion about those rules. But part of the issue that we identified is that about 30% of our diversion cases involve technicians, and we have made it a point to be able to regulate them. So when those rules are finalized, they will be subject to the same process as far as discipline as a pharmacist would be. So if you're here this afternoon, you'll hear more discussion about the technician rules.
And not just to discipline technicians. I think we all expect, we all, as we've worked in the profession, and you will learn very quickly as you, if you are an intern, you already know it, as you begin your rotations, you'll see it. We depend highly on our technicians to act and conduct themselves in a very efficient, professional, and accountable manner. And the patients of the state of Ohio expect no less than that. So while the rules do talk about discipline pathways, we also talk about training and education and all of the things that we need to do to assure that that cohort of co-professionals, if you will, are at a level that we believe they need to be in order to conduct pharmacy business appropriately in this state. And I think we've come really, really close to getting those rules in play. So if you've not taken a look at them, do so. There's a lot of them. And so it's a good thing to read, because as a responsible pharmacist, you are also accountable to some degree for the actions of your technicians that are working with you. So just be prepared to understand how they should be acting as well.
So kind of going off of our previous question, more specifically, like how many extra hours on average per week you say being on the board demands? And in addition to like prescription dispensing cases, what other kind of cases do you typically hear, and what's the most bizarre one that you've been a part of or heard about?
I guess I can take the first question. So typically we have our meeting days are about 8 hours, so a typical work day. In a month we have the 3 days in a row, about 24 hours, 8 times 3, right? My math is right. A few other board members, we do sit on other committees that you'll hear part of our business throughout the month that we'll have to attend and report back to the board during our board business. So we sit on the medical board has the physician's assistant committee where we sit on their formulary review. So we will sit in there and be that subject expert within that group in order to approve the PA formulary. And we also have Mr. Pacifume, who is overseeing the medical marijuana commission at this time, so he will report back to that as well. So all those rules are through the process, and he is overseeing that. So I'm guessing his workload this past couple of months has been much more substantial than ours as other members of the board.
If you look at the number of entities that we license, that will help tell you what kind of cases we see. We issue licenses through the state to not just pharmacists and pharmacies. So that will help understand kind of our oversight. In this state of Ohio, I think the board, by designation, by authority of the license that we issue, we do have a wide look into areas where medications and drugs are handled in the state. And I think that's appropriate. I think there's no better profession to be able to oversee that. Unfortunately, I'm here to tell you that we are not immune to opioid addiction. Our profession, unfortunately, is one of the highest addiction rates amongst healthcare professionals. That's a reality that we have to wrangle with. And we do see addiction cases. That's the fact of the matter. And they're tough. But I will say, while as tough as those are, it always makes my day and the board of pharmacy better when we see somebody come back from that. When the discipline that we've issued, the guidance that we've given, the pathway we've put them on to successfully re-enter the profession actually happens, and they come back before us for a reinstatement of our license. That's a good day for me, when we can actually see that happen and make a difference, not only for the patients in Ohio, but for those individual professionals as well.
How many of you will not be here in the afternoon? So here, I'm not a pharmacist. I've only been here about 3 years. You asked about the types of cases and maybe most bizarre. To me, it is quite bizarre that a bright man or woman would throw their career away because they have fallen in love with somebody that wants to have the keys to the medicine cabinet. And while I'm not here to give you like couples counseling or anything like that, but career counseling, you are entering a profession that for someone that is manipulative or addicted or all of the above, you will hold the keys to the medicine cabinet, and that is a big deal. And I encourage you to be mindful in your relationships to make sure that that is not what the draw is. Because I've been shocked by the number of cases that this board hears where that's exactly what happens. Somebody is thrown away, and typically it involves a criminal conviction as well. But be careful with that.
So I have two questions. Being on the board, like, has it caused you guys to be kind of more cautious in your practice? And with that, if something were to happen to you guys, like some kind of error or anything, do you receive a harsher deliberation?
So as I said before, we don't get a get out of jail free card. Here's the analogy I'll give you. I'm also a motorcycle driver. When I took my motorcycle safety courses, which was not in this state, I'm originally from Indiana, understanding the complexity, the rules, all of that went around that, made me a better driver in general, both of my motorcycle and any other vehicle I might drive. I think that analogy for me is not too far off for this. I think that as an organizational leader, I can help my team understand the rules. Am I paranoid about the work? Absolutely not. I mean, we have to practice our profession every day, and that's the majority of what our work is. We walk a careful line. I can only speak for me. When I sit in leadership meetings in my organization and issues that are pertinent to the Board of Pharmacy come up, and they do. New rules are coming, or there's a practice we're doing as a compliant. It's not my job to sit there and rule as the board. I do that when I'm in this meeting. We have resources that guide my organization around board compliance. I connect them, to them all the time. So I don't know if it makes me a better pharmacist or a more aware pharmacist in practice, but knowing how to access the resources. And do I understand the rules better than I did 3 years ago? Oh yeah, without a doubt. But I can't say it's fundamentally changed the way I practice or the way I ask my team to practice. We have to kind of draw a line between there. And just to be clear, if I, as a practicing pharmacist, were to violate a rule, I would be handled exactly the same way as any other profession in the state of Ohio. I do not get any special exemption for that.
Regulatory field, and I have actually had other clients where one of the sitting board members has had a complaint filed against them. It's been my experience through the Office of the Ohio Attorney General, we generally counsel, many times we will go to a different agency and have a different investigator from a totally different profession enter into an investigation if we feel that's, recommended, so that you would remove any potential issue of favoritism, because the board does not want to be put in that position. And the board ultimately would have to make the decision, but we would want to have the facts be as cleanly presented as possible, so as to remove any potential indication, because it's so important that the professions, any profession in the health field particularly, maintain its integrity.
We have about 5 more minutes.
Just to finish that, there's a process that we can recuse ourselves. So many of us have lots of people that work in our organizations, and we may have cases that come up that involve associates that we work with or know about. So we have to be careful that we give the opportunity to step back from that, so that we don't introduce bias in the board, and we have a recusal process that we can just step away and let the rest of our board members handle that work, and then we come back later and continue on. But that's a tool that we can use to kind of keep things at arm's length.
Please.
This is a little off from the hearing theme that we got going on, but when the Board of Pharmacy visits a site like a hospital or pharmacy, who does that visit? Like, it's obviously not you guys, I'm assuming. Is that one of the employees?
The inspectors, the agents, and the specialists were all assigned to different locations throughout the state. So we're local. We all live in different parts of the state, so we can get to places quickly. Inspections and investigations, we do both. So you might see an inspector. They're newer to our agency. Those are pharmacy technicians that are trained to do inspections. Specialists usually handle things that have a complex system, like a hospital system, something that might have electronics, serial compounding. And then our agents are a law enforcement background, and they handle everything in between and most of the investigations. So there's many levels to what we do.
And most of them have a pharmacy background to begin with?
There's 8 specialists, and there will be 8 inspectors who are the pharmacy technicians, and a bunch of agents. 20 maybe now, maybe if not more, than agents that we have with law enforcement background.
Good questions. We'll take one more. Is there any other burning desire question that you feel like you need to ask? Oh, we got one over here. Absolutely. So I think I can take this one. So if there is an immediate evidence that shows that we need to be able to pull somebody out of the practice immediately, and the evidence can support that, we are called. We can have summary suspension hearings over the telephone. We don't have to have all the board members come down to Columbus just to be in person. So what we'll be on a phone call for a summary suspension. One of our specialists will actually present evidence to us that will support summarily suspending a license. So that's the immediate pulling of that license. It's for 90 days. Is that correct? We have. Did that answer your question? Good, perfect. Anything else? Well, I think at this time we are going to recess until 1 o'clock. We're all going to go to lunch, and we'll see you guys back here at 1 o'clock then. record here. Am I on? Am I on? Hello? Can you hear me? John? No? Hello? Okay. There we go. How's that? Perfect. All right, we'll come back into session then for the afternoon of board business then. For our medical board PAPC committee, Mr. Cox is not present, so we will go ahead and submit a no report at that point. Mr. Passafume, would you like to give us an update on medical marijuana?
I will do that, Madam President. While the Medical Marijuana Advisory Committee has not officially met since the last board meeting, we have continued to work through processes, not so much around rules, but around applications review. We're kind of in that period of time where now everything's starting to work. So I'm not sure where Commerce is getting through their final review of the grower applications, but I believe they're prepared to issue. And I'm not sure how many, Aaron's not here, how many dispensary applications is that window even open yet?
No.
No, it's not even open yet, so.
The first comment period is out there that you proposed the first draft of the application.
I'm just looking at that. Help him.
The first draft of the application is out for public comment.
Great. In discussing with Ms. Reed, I believe the seed to sale software application contract has been settled. So we have, I think, a vendor in line for that. Lots of dialogue in the physician community now. That's where we're at. As physicians now are inquiring about what's the latitude, what's going to happen, what are organizations going to allow. Their process was published finally for getting their applications in. So I've been on the road for the board, I don't know, probably 3 or 4 times. I have 2 more coming up, and we're in that discussion phase about what the rules mean and how we're going to actually execute this. Just as anecdotal, I think many of you know I was in Colorado a couple weeks ago on a personal vacation and had an opportunity to visit some dispensaries there, both medical and non-medical. Hoping that some of what I saw we'll see here, hoping some of what I saw there we will never see here. So it's all over the board out there. So we are slated to meet again in December, and I should have more information for the board at that point in time.
Great, thank you, Mr. Passafume. I'm going to turn it over to Mr. Shearholt for our staff reports.
Okay, legal report, Nicole.
No news continues to be good news. There was a question earlier from the audience about any appeals and how that would work, and fortunately the board does not have any cases currently pending appeal, so I do not have an update for you on anything related to that.
Okay, compliance report. Eric is interviewing candidates for open positions, and our chief pharmacist, Jenny Way, will present his report.
Going once? There it goes. Good afternoon. I would like to start with sharing a few of our highlights from the past month. On September 26th and 27th, Eric and I attended the FDA Intergovernmental Working Meeting on Drug Compounding. It was very educational. In that meeting, we had gone over some of the guidance documents and some of the new proposal from the FDA. In particular, some of their new initiative that's going to be coming out. One of the things that they are going to be doing is going to be sending state referral letters whenever they have findings that needs some of the state's attention. They will be sending state referral letters. In addition, one of their new FDA initiative is going to be doing education sessions when it comes to compliance, common observations identified, and how to do inspections in the 503A and 503B facilities. The other thing that they had discussed a lot about is how to further collaborate with FDA, whether it's what they call a 20.88 agreement, where they can share more information with our agencies. And I think we are currently in the process of trying to initiate the 2088 agreements, and also we are thinking about maybe commissioning several other folks in our agencies to be able to have more privileged information, such as 483 findings and such. So They had some sessions on special compounding that surrounds veterinary compoundings, radiopharmaceuticals, hospital cares, and long-term care compounding. Overall, it's very informational, and we'll be sharing some of those information in the future. Furthermore, with Cameron's assistance, we have obtained another ORS grant to focus on early interventions on doctor shopping for those individuals. Mr. Shearhole, I'm not sure if there's any further information you wanted to share with our this new grant that we just recently received.
Sure. So I think you were all aware that we applied for a BJA grant to fund 2 agents for 2 years, and we've called it essentially a doctor shopper early intervention initiative. And what it amounts to is that using the PDMP data, identify those that are doctor shopping and approach them. Have in place a prosecution deferral agreement from a local county prosecutor, have in place a treatment option for immediate placement if it's required, and ideally a local detective and one of our agents would essentially go knock on the door and say, you know, based on the information that we have, it appears that you are violating Ohio law and that you're engaged in deception to obtain dangerous drugs, which is a crime. However, we are not here for that purpose. We are here to work with you and try to get you to seek treatment. What the experts are saying is that if someone is putting all that effort into going to five different doctors, filling scripts at 5 different pharmacies, and for this purpose in the 3 calendar month period, ideally, or probably I should say, they have not graduated to injecting heroin. And what I'm told is that the probability of successful treatment is greater before they transition to heroin, and the cost of treatment is less before they transition to heroin. And we intend to pilot that. Our grant application was through Department of Justice, Bureau of Justice Assistance. However, it got the attention of the acting director of the White House Office of National Drug Control Policy, and his name is Richard Baum, and he was in the Columbus area, I don't know, a couple weeks ago, and asked to meet with us about it. President Marshall attended, Director Plouk from Mental Health and Addiction Services, Chad Garner, our ORS director, and I met with him and a couple members of his staff, and he was very interested in that intervention type, going upstream in the addiction process. And what was interesting is we still at that point did not know if we were going to get the grant or not. He left at about 5 o'clock, and at 10 o'clock that night we got the email saying we'd gotten the grant. If there, and what we will do is select 2 incumbent agents that have probably superior interview skills to fill these positions and then backfill for this purpose. Be happy to answer any questions if there are any.
Just maybe a question for you or a question for the state in general. I was happy I was able to attend a annual presentation by Mary Haven, and they were talking about the state of the state as far as rehabilitation capacity in the state. Has that come up at all during finding and interdicting in these pre-heroin patients presupposes we can effectively get them into treatment? I'm assuming is what that presupposes. Do we have a sense of what that capacity looks like? Are we growing it quick enough?
Well, I don't know if we're growing it quick enough. I know that in Franklin County, where we intended to pilot it, we've made arrangements with a treatment provider to be responsive to that scenario. I think essentially what we would do is work with local law enforcement and decide, okay, on Thursday, October 12th, we're going to do this list, and if you go to the first door and nobody's home, then you go to the second door and do that, and the treatment provider, knowing in advance that the 12th is the day, will hold a bed.
Okay. Okay, thanks.
And we hope then to replicate that, and the prosecutor, because the prosecutor really is the only person that can say, I will not seek to prosecute you under these circumstances. And we've worked with Franklin County to craft a prosecution agreement, and then now that we have the grant, we'll try and move that to other counties as well.
Thanks.
Mr. Shareholder, at this time, do you know about how many people would fall into that criteria?
Ohio typically, and this is certainly predates me, but Ohio typically defines a doctor shopper as 5, 5, and 1. 5 controlled substance prescriptions from 5 different providers filled at 5 different pharmacies in 1 calendar month. That number has decreased even in the last 3 years from over 1,000 to 300 and some. Most states in the country use the definition of 5, 5, and 3. 5 prescribers, 5 pharmacies, and 3 calendar months. At any given time in Ohio, using the 5, 5, and 3, that number is probably a little bit less than 700 individuals in Ohio.
Thank you. Any other questions?
To continue on the report, we recently conducted our annual compliance enforcement fall staff meeting, and that went very well. We actually had guest presenters from Health and Human Services, the Office of Inspector General, as well as Bureaus of Workmen's Comp, and the Ohio Mental Health Addiction Services. As far as staffing update, we currently now have 5 new candidates in the background process, 1 compliance specialist, 1 agent, and 3 inspectors. Additionally, we are continuing the interview process to fill the new agents and inspector positions. From compliance overview, we are continuing to be very extremely busy. Members of the staff have also attended the International Healthcare Facility Diversion Conference, which was very informative and educational. We also took part in the quarterly pill mill coordination meeting with all of our states and federal partners. The rest of the compliance report is attached into the executive director report. Do you have any further questions?
I do have a question. Hopefully you're aware that USP gave us guidance in the last couple of weeks that final compliance timeline for 800 and 797 revised has been pushed back now to December of 19. Just curious what the conversation around the office, particularly around the inspectors and compliance specialists, if that changes their approach, or what the conversation might be around that change in timeline.
I'm not familiar with the discussions currently in our side yet, but I am aware of the change of the date. Furthermore, I think we're also waiting for the FDA, which is going to be coming up. They're going to do some educations for us. I think that's going to provide a little bit better guidance as far as also if they're looking into even with USP 800s. When I've asked them, had the opportunity to ask them, there have been very few discussions regarding to USP 800 from the FDA level at the meeting currently.
Cameron, do you have anything to add? You've been living this. Do you have anything to add to that?
If I can also make an addition, I have passed out information on that I've sent to you guys. It's called the Phil Pharmacy Solutions. I want to take the opportunity to discuss with you and to make a mention. It's really for your information because this is, I believe, kind of a new concept from as far as pharmacy perspective goes. The board received a new application for a remote order entry only pharmacy that was submitted back last month. And it was assigned to one of our specialists for review. And when we started to look at what was on their website and what was proposed to us, we raised some questions. The company itself is that's applying for the licensure is called PhilRx. The parent company is Phil Pharmacy Solutions. And Phil Pharmacy Solutions, the reason why I raise questions is because it's very new. It's what they call a virtual marketplace. If you kind of think of it like a Priceline.com or a Grubhub, where the Phil Pharmacy Solution is basically a technology platform where patients can enroll and they will find local independent pharmacies that will fill the prescriptions and mail it to the patient's home. And they've been doing this business since 2015, and they have about 8,000 patients that's currently in their program. What they're looking for in Ohio is actually to be licensed as, when they say remote order entry pharmacies, when we ask the questions, it's really about consulting pharmacies. So what they want to do here that's different than what they currently have is that they want to establish a pharmacy here in the state of Ohio where they're going to receive the e-prescriptions. And when they receive the e-prescriptions, they would validate the information with the pharmacist. They are planning to hire one pharmacist and about 2 to 3 technicians, essentially just transcribing the prescriptions into their system. And then they would then transfer the prescriptions to the independent pharmacies. Now we kind of question, I see some of your looks because we're kind of wondering, make sure that the business model is legit, and then to raise any questions to make sure that they follow our pharmacy practice in Ohio. Last week, we actually invited their head of operations as well as the responsible pharmacists on their license to come into the board for a discussion. In our meeting, we have our board personnel that included our compliance enforcement specialist, Eric, Mark Keeley, and those are listed here, as well as our legal counsels and our licensing director there, just to kind of ask questions because it is very kind of foreign in that concept-wise, so we had a lot of questions that we wanted to ask. Like I said, what they wanted to do here in Ohio is that they wanted to receive these e-prescriptions, and this is not paper prescription, but they want to receive these e-prescriptions and then vet it through their platform, and then transfer those to the retail pharmacies, independent pharmacies, and the independent pharmacies will then fill them or dispense the medications. The DURs and everything else will be done by the dispensing pharmacists. And the reason I kind of asked them to, so why are we being the middleman? And it's really for expediting services. They, right now, are not being licensed as pharmacies, so they're not onto the SureScript. So so if a patient go and ask the prescriber, hey, I want to have this sent to my pharmacy, they're not on there. So the reason why they went to apply for this license is to make sure that there's consistencies and also vetting through the prescriptions process. They do have a compliance monitoring program. They do check the controlled substances, and they also vet through the pharmacy. They have inspections and the folks that are on the ground to do the inspections there. We vetted a lot of the questions to them, and we feel that they have vetted through some of the questions that we have, especially regarding to what's your business model, who is your physicians, why you wanted to do it in Ohio. And so all in all, they actually currently have 2 contract pharmacies servicing their patients in Ohio. One is a one is a mail order pharmacy that's located in California. The other one is through Klinger's Pharmacy that's located in state. Upon our issuance of the licensure, we will be conducting an inspection to the Klinger Pharmacy as well as the site location in Columbus, Ohio. But I want to mention this to the board because it is a very different concept of services-wise. So I want to make sure that you're aware of it because we will be the first state to license them.
So a question, I'm curious, are we planning on visiting the contract pharmacy? I'm trying to understand from a contracted pharmacy's perspective, what is the incentive to be in a relationship with this organization? I'm not following that.
So they're targeting most independent pharmacies. What they're doing is that in order to, it's a technology company, and the way of revenue for them is the pharmacies have to be a contract service with them. They have to purchase their platform and their technology services. So a patient actually has an app on their phone that they can request refills. They also have a concierge service where if a patient is out of refill, they have an advocate where they can contact the prescriber to get refills, as well as doing first steps of prior authorizations. So it's really kind of linking the independent pharmacies who are maybe remote and getting the patients their medications as mail order or sent to them at the residential place.
And I looked at your workflow diagram, or maybe it was their workflow diagram. And again, putting myself in the role of a patient here in the state of Ohio, who do I talk to? Who do I talk to as a patient? Do I talk to Klinger? Do I talk to Phil? What's the way that patients access this relationship?
So the patient access to the PhilRx company. So they essentially serve as, like I said, a patient concierge service where questions in regards to the refills and their services goes through the PhilRx. The actual dispensing goes to the independent pharmacies. PhilRx is not going to keep any printed or hands-on prescriptions. They will only do e-prescriptions, and then it's going to get transferred. So if a patient then comes with a paper prescription, they have a process that vets through where they will have to send the paper prescriptions to their contracted pharmacies.
Okay.
I guess my only comment on the surface is my concern would be patient safety. Anytime there's a middleman that actually doesn't do the work, they're not doing DURs or checking. We're starting with a nurse or physician going to a pharmacist and tech who's giving it to a pharmacist and tech giving it to a patient. And the more times things are transposed and rewritten and retyped and redacted or rewritten, that's just my one concern is maybe nothing illegal with it, but that's just a patient safety concern that always increases. I would relate it to a nurse calling Walmart to call it into Meijer. Mm-hmm. There's a whole gap there where an error can occur. So that's just my professional.
Actually, we asked that question too because one of our main focus is really about patient safety, of course. So we asked specifically a question about what is the responsible person or the actual pharmacy in Ohio. What is their process and what is their function? Are they going to be performing DURs, or are they just transcribing service and just typing whatever the image says? But they answered that they will be doing the DUR even though they're not doing the dispensing. They will go through the DUR, the drug interactions, as accordance to our pharmacy practice codes, and that they do have a compliance monitoring system where they actually do audits. So whatever gets dispensed, they actually require 60 of the hard copies of whatever they dispense to match what's been transcribed, and they do have an auditing process. We want to make sure that was the key because we understand when it comes to transcribing, it's like the telephone game. A person gets transcribed and then gets transcribed again. So this is all done through e-transfer, e-transcriptions.
Thank you.
Any questions?
As I recall the discussion, at first blush, I think the staff response was different than what you're hearing now. I think at first it was, no, heck no, there were concerns. Then there was this meeting and further discussion where the staff arrived where they are now. If any of the board members have articulable concerns before we go down this path, I think we need to hear them sooner than later.
So is the intent to issue the license?
Yes.
That's what I'm reading here, is that the intent is to issue the license.
Yes, our intent is to issue a license, and the reason why I brought this forward to you is to make sure that the board is aware of this concept, because it is fairly new, just like when I first heard it too, and our team first heard it. There are many questions and wondering the legitimacy of this business. So we felt that it is important enough to share with the board and to inform you that this is a different type of business model. We vetted through. I felt that our team did a great job in vetting through the concerns and questions similar to the questions raised today. they got 6 other pharmacists plus the legal and licensing asking them the same questions too. And so the point of it today is that we'd like to issue them the license, not as a remote order entry pharmacy, but as more so consulting, because they're not doing the final dispensing. It doesn't just go through them and then the medication gets out. It goes through the actual independent pharmacies, the contract pharmacies, before the dispensing. So they're really serving as a middleman to just kind of get these scripts expedited to the contracted pharmacies.
And the compliance department is confident that should the need arise, you can work back upstream with clear accountability on, again, worst case scenario, error in entry leads to an error in dispensing. Now there's patient harm. We're looking at a multiple discipline case. It's not like a central fill where you have an organization that has a local site and a central site. This is different than that.
Yes.
As long as you guys are confident, you have and will be granted the access to all of the records, the data that you need with full transparency, as opposed to be chasing something if a case should arise.
Yes, and that's why we would like to make sure that they're licensed with us in the state, so that way we have records to their dispensing. And as I mentioned before, we ask them very specifically what's actually their function. What is the function of their RP and what's the function of the pharmacist? They're, it's not just transcribing, but that they're actually doing pharmacy practice work, looking at DURs, looking at interactions, diagnosis, even looking at our WARS report. We had asked them questions about the controlled substance monitoring. Are they just going through all these controlled substances to these contracted pharmacies? So they do have a compliance program too as well with controlled substances.
So and we have so many license types. Once again, I don't know them all, but is a consulting pharmacy license the correct one? Because if we have a pharmacist that is doing a data entry and doing a DUR and then transferring it, that pharmacist is actually they filled that, well, they didn't fill it, but they approved that prescription, they validated the DUR if they had everything. And so that's my next question is because they're really not consulting because they are checking the script.
Under whichever pharmacy it is, they will also have to practice under our 4729 guidelines from the pharmacy practice perspective-wise. We felt that with the remote order entry, they're not the last person dispensing. So sometimes with remote order entry, I'm entering and I'm going through that, but then the medication is directly, whether it's through like an automated dispensing machines or somebody else that doesn't do the final check dispensing. That's really not the case. Somebody else is actually doing the final check with the product, with the prescription, and the patient. So essentially they're doing the same work. They're doing double the work-wise without the actual dispensing.
So will Phil transmit the original prescription to their contract? Because in a remote dispensing, that second pharmacist would still have access to that original and be able to do their due diligence. Many times with transfers, you get a computerized version, not the original version.
So these are so they are transferred through e-prescription and their platform that captures the image. So they don't do anything of paper capturing image-wise goes. So all the data flows would essentially, the correct fields would go into the independent contract pharmacies. That makes sense.
So I guess in the world of e-prescribing, sometimes e-prescribing causes errors because the doctor will type once a day in the SIG, but then in the note field at the bottom put, patient should take twice a day. And you have to see that whole image to actually catch the total prescription. And my concern there is making sure they get the exact electronic image the first time and not the typed version, because to the contracted pharmacy, both are going to be electronic because you won't ever see handwriting.
Yes.
And so they're going to see the original e-prescription, so where they'll see notes that are typed in the wrong fields to make sure they can clarify the order.
Yes, they will receive the original prescriptions from them. They're essentially capturing the information on their own platform, so that way that it kind of connects with the patient portal and the contracting pharmacy. The contracting pharmacy will have their own website that will alert from them in the queue. So it's actually essentially dumping everything into that. So their technology is really that kind of, I call it patient portal, or that portal, they call it the marketplace.
Okay. Thank you.
Yes.
Patient wants to transfer a prescription, who do they call?
They will call PhilRx. Yep, they'll call PhilRx. If a contract pharmacy drops off or is no longer with a contract, they will inform the patient and they will hook them up with the next closest pharmacy. And the patient always has the choice to withdraw from the program. It's free of cost to the patient, and they can always withdraw from the program or request another pharmacy.
And if there are no contracted pharmacies in Ohio?
Then they would not be able to service the patient. They'll inform the patients of that.
Okay.
Do you have anything else?
No, I do not. Thank you.
Well, I will deliver licensing. You have in your executive director report reports of numbers of licenses and the like. We currently are interviewing. There are 2 current vacancies in licensing. It still looks as though we are going to get a 3rd licensing coordinator on January 21st, which will be the transfer from the Respiratory Care Board, and it's the individual at the Respiratory Care Board that handles the home medical equipment licensing. So our licensing staff is slated to increase by 3. And I think there is an extension request that Nicole will handle later under new business. Are there any questions of licensing? Okay. And I hope you understand, Eric is doing interviews. Chandra, frankly, is swamped, as is Chad, and that's why they are not here. From Chad, so I think we've had discussions that we were seeking funding. You know, we have the $1.5 million per year from the governor to integrate ORS into the workflow. We have sought federal funding to integrate NARCS Care into the workflow, and we've gotten word that we got that money. So we, the Gateway product that we're currently supplying is going to be enhanced with NARCS Care for the hospitals, pharmacies, and physician offices, and that will be going forward soon. And in fact, if we can get the contract signed and get this rolled out, we will be the first state in the country to integrate NARCS Care into the clinical workflow and provide it as a state. We have another vendor that wants to charge Ohio licensees for services that we believe we're already paying for, and we're going to have a conference call with them later this week. I'm anticipating it will go much like the last one of these calls that we had, where we take the position that we will not pay for the integration if that particular vendor is going to additionally charge that licensee, and we'll see how that goes. Chad and I were at a nationwide PMP meeting a month or so ago, and Arizona is going through the same thing, and they are very grateful for the stance that we are taking because it's making it easier for them with their vendors. We continue to work through some issues with APRIS, our PMP vendor. They were in town the 5th of this month, just trying to work out our ORS system. I guess for our audience, our ORS system was a legacy system, and it was no longer being supported. So we recently switched to Aware by APRIS, and we're the largest PMP in the country that they've transitioned, and we've run into some issues, but continue to work through those. One of the things you're going to see for the board in your reports is the number of ORS queries per day. That number from now on is going to appear to be lower, and that is because without absolutely just manual calculation, it now includes weekend days, where in the past it was just weekdays. And that is, I guess, showing the number is decreasing, where in fact, I think you've heard me say that when we announced the ORS integration into the clinical workflow, we were averaging roughly 65,000 queries per day, and we are easily over 350,000 queries per day. As part of Senate Bill 319, we were authorized to grant ORS access to drug court judges, and that is going live this month. And the ASAP 4.2a, which is the standard that allows the ICD-10 code to be entered into the system, that is going to be up and running this month, and then it will be for the individual vendors to accommodate that. Do you have any questions about ORS?
Steve, I have a question.
Yes.
So do we anticipate with the new ASAP format that goes live in October, December 20th or so is the day that opioids have to start being transmitted using that? I know we discussed extensions if needed. Do we anticipate anybody being live at that point with about a 6-week window?
Speak up. Cameron McNamee is our Director of Policy and Communications, and we had a stakeholder meeting 2 or 3 weeks ago. Well, actually, we've been having a series of meetings, and I know that Cameron has had the most contact with the user community, and he is headed to the microphone now. He's not. So the question was, who's going to be up and running on day one or thereabouts?
In terms of e-prescribing?
Being able to accept the ICD-10 code.
So in my discussion with NACDS, they have not expressed any concerns because the ICD-10 field is included in the NCPDP format for all of the dispensing systems. So you will be able to receive it electronically. The issue being is the PCS systems from the hospitals, mostly the hospitals, because they're really the only enabled systems that are really using EPCS because of all the meaningful use requirements. And so for those systems, we're kind of working with OHIP, which is the Ohio Health Information Partnership, which helps hospitals sort of meet meaningful use. And they're currently doing a survey to see where systems are in that process. And they're working on a survey to look at the difference between can they provide you the code and is it convenient for them to provide you the code. So can it be in the notes field instead of, so they're going to look at if it can actually be transmitted and how it can be transmitted, and then looking at whether or not the systems will also be upgraded in time to be able to do sort of a drop-down menu from the prescriber side. I have heard of a few systems. I know Epic up in the Cleveland Clinic should be coming online shortly before the time frame, and we're looking at some other systems to see if what their operational issues are there. But it's kind of a all hands on deck when it comes to the OSMA, the Hospital Association, us, the Medical Board, and even folks from the Office of Information Technology with the state.
We feel our community partners, pharmacies, I mean, earlier today we discussed QS1 in one of the cases.
Sure.
All those systems are able for it to be entered and transmitted?
So in terms of, you mean transmitting from ASAP 4.2a?
Yeah.
We have not received any pushback from that, and so we will probably send out this week another reminder about the move to ASAP 4.2a, and we certainly can put some additional information to have them contact us if there are concerns, because certainly we would want to know who can and cannot. To my knowledge, there was no feedback during the process, in the rulemaking process. That sometimes is not indicative of there not being a problem, but we will kind of pay attention to that as we move closer to the implementation date.
Thank you.
For the students, what this last discussion emanates around is in Senate Bill 319, which was signed into law by the governor in January of this year. One of the provisions allowed the just stay seated. You're okay. One of the provisions allow the prescriber boards and the Board of Pharmacy to further regulate opiate prescriptions in rural as opposed to statute. And when that became effective, the prescriber boards implemented rules that limited acute pain prescriptions to 7 days for adults, 5 days for children, and then the Board of Pharmacy required the first 4 characters of the ICD-10 code to be placed on that prescription. That piece of it for opioids will go into place at the end of the year, but for all controlled substance prescriptions, mid-year next year. And this discussion was about the technology being able to accommodate that, and particularly with e-prescribing. So that's the background there.
Cameron, we were having went through some discussions.
Mike.
Perfect, thank you. Through some discussions with Epic, we were discussing that our ambulatory is not going to be an issue. They were hoping, have there been discussions with SureScript, the switch, to ensure that the ICD-10 code, they're going to be on the same platform as well? That's their concern. They said our systems are fine, but we're concerned about SureScripts. I would assume so, but I would assume
so just because it's part of the NCPDP standard format, but I can email Ken Whittemore at SureScripts and follow through and just double check to see if it's on.
Because I share and echo Sean, Mr. Wilt, that there is that concern of, are we going to get to our December board meeting, 2 weeks prior to, and have to issue some type of, resolution that we need to push this back due to technology. And I guess for the students, this is a great example of we're creating and writing rules and approving rules for the regulation to make sure that for pharmacies to uphold these, but we need to make sure that we're not being a burden on these businesses across the state of Ohio, and that they can support whatever rules we're putting in place and we're approving as a board. So.
Can you hear me now? This piece of this from the Board of Pharmacy is to make the medical board, nursing board, dental board's rules enforceable, because there were exceptions built into this 7 and 5 day rule, and without this ICD-10 code, those rules were just unenforceable, and you have no idea what the exceptions, if it meets an exception or not. Additionally, we think over time, given the opiate crisis in Ohio, that there might be some valuable data that accompanies this as well. Okay, any other ORS type questions, related questions? Okay. I think a couple of other things. So we have, I met with under some new statute, there have been some healthcare boards that are being abolished and rolled into other boards. It affects the Board of Pharmacy in that currently the Respiratory Care Board licenses home medical equipment suppliers. That board is being abolished, and the HME piece of that is coming to the Board of Pharmacy for regulation. I met with their association and got a tour of a Actually, it was an Ohio Health affiliate up in like the Lewis Center area, and just gave some comments to their annual meeting. It should be probably less than 1,100 licensees, and the law goes into effect January 21st. We're having some discussion. There is the board will end up appointing an advisory committee, and we're discussing when that will be effective. One reading is that it wouldn't be effective until January 21st. Another reading that the medical board is taking is that it's, I think, this month sometime. So we're looking at that. As you all know, on the board, in September of last year, our authorized strength was 57. Our authorized strength of employees right now is 86. With this grant, it's going to go to 88, and that's putting a strain on our HR department and the hiring managers that are hiring that many staff. So that's one of the reasons Eric is not here. But we continue to work through it. So if there are any balls that are not being kept in the air that you become aware of, please let us know. We have. Do you want to touch on this stuff now?
Yeah, that's fine.
So District 4 is coming up November 1st, 2nd. NABP's District 4 is coming up November 1st, 2nd, and 3rd. Brenda is taking care of registering and some travel arrangements if you need it. So each of you, please make sure that you're clear with Brenda what your plans are, and if you're going, not going, and what you need from her. I think that's all I have right now.
Okay. All set? Pardon me, thank you. So moving on to new business, we are going to discuss, turn it over to actually you, Nicole, Ms. Dana.
Thank you. On behalf of the Compliance Department, Eric Griffin received a letter from Walmart. The board may recall it previously granted an extension for Walmart for the storage of records to be in compliance with Rule 4729-911. And the Walmart has reported to us that they have been able to meet the deadline in all locations except for 3. They did have a delay from the supplier in manufacturing the parts necessary for the cages for the offsite storage of records. And they are assured that by their supplier that the work will be done by October 30th. So they are asking for one more extension for those 3 locations. If the board is so inclined to make a motion to grant the storage extension request, just on the outside chance something happens with the supplier's materials again, perhaps we could grant it till the November 13th meeting. That way, if they needed one more extension, we would be able for them to meet that without being out of compliance.
Madam President, I'll make a motion that we extend Walmart's extension until the November board meeting.
I'll second.
Thank you very much. All in favor of the motion? 6-0.
Thank you. And on behalf of the licensing department, since Ms. Palanti could not be with us today, she requested that I bring before the board an extension request of an intern. Ms. Casimir failed NAPLEX 3 times and is approved to re-examine. It was to be done on September 18th of this year. We do not yet have the results. I know that Chandra was looking for those results as recently, I think, as Thursday or Friday last week, and she did not have them yet. Her initial license was granted in September 1st of 2011. She graduated May 6th of 16, and she did have a renewal of her intern license granted May 31st of 16. So she has tested, she did pass the MPJE August 31st of 17, And she did have 3 failures of the NAPLEX, but intends to take it again, or did just retake it. So she has asked if the board would be so kind as to grant her 1 more extension, and indicates in her letter that it helps with her studying to be active in the practice and stay current with pharmacy while she is studying.
Board members?
Ms. Daner, I have a question. Why did her license expire in May? Why did she not get the standard September license expiration date?
Unfortunately, I cannot answer that question.
Was
It may be because you granted an extension, and so it may have gone to the following, from the time she graduated. That would be my guess, but without talking to Chandra, I don't know.
I do believe this was only a 6-month extension from, if my memory serves me correctly.
So she graduated in May in 16, and you're permitted to renew 1 time post-graduation? So she would have renewed in September of 16, which would have been good till September of 17.
I can't answer the timing question, I'm sorry.
I'm not sure either.
If it's determinative, we can pause this and
I would recommend that we get some more information from licensing, and then we can further discuss it to make sure we have all of our timetables correct.
So we need to know why it was renewed in May as opposed to September?
Right, why would it have expired? When did it
Just a
expire,
simple
maybe?
timeline of her license progression would be helpful here. If there had been extensions, put them on the timeline, when the expiration dates would have been, just kind of give us the story about what happened with her, and the extensions we granted.
And she failed the NAPLEX 3 times already, took it a 4th, but we don't have those results yet? Is that what?
Correct.
Yeah, if we could just validate that, whether it's she failed twice and is asking for a 3rd time or failed 3 times.
And why does she feel she needs another extension?
So she can continue practicing while she studies for the exam.
In case she failed it a 4th time?
Yes. I think her request came in, her request predated her testing. So her request came in August 31st, and she took the test September 18th. Yes, I am.
Would you like to proceed? Okay, we'll table that one until after our exciting legislative and rules update with Mr. McNamee.
Let me get comfortable here. Good afternoon, everybody. I want to start with, we have 5 resolutions that I would like to seek your approval regarding. So in your packets, in your plastic binder things, your meeting packets, you should have that in the presentations tab, both that and the rule documents. So it should say resolution number 1, printing electronic prescriptions. So we had discussed this issue in July, and there were requests to look at stopping this practice now while we look at rules, update rules to the retail pharmacy chapter, which will go through rules review in October. I think it's the 25th or the 26th that we're meeting. So Resolution 1 talks about the printing of electronic prescriptions. Currently, 4729-521 does require the electronic prescription to be printed in order to document the dispensing. And what this resolution would do is essentially say, if you can document the dispensing using using positive identification, there is no requirement that you print out the electronic prescriptions anymore. It should be noted that in our discussions with DEA, they don't necessarily love the fact that printing out electronic EPCS prescriptions, but also these also apply to the non-controlleds. And so basically it says that the pharmacies will no longer be required to print and save hard copy prescriptions if the pharmacy can comply with all the following. The pharmacist is able to document the dispensing of the original prescription using positive identification as defined in 4729-501, and the prescriptions must be stored electronically and shall be uniformly maintained and readily retrievable for a period of 3 years. And at the bottom it just reiterates that existing printed electronic prescriptions may be destroyed if the prescriptions are stored in accordance with the requirements of this resolution and the prescriptions are not used to document positive ID. So if there's another method of documenting positive ID for the dispensing, then you're able to destroy all the prescriptions that you've had to print out. If not, then you would still have to maintain those. And then we just clarify that if those are destroyed, the electronic prescriptions are deemed the original prescription, just in case you get a PBM auditing you.
This is for controlled and non.
This is for everything.
Everything.
Yep.
Controlled and not controlled.
Mhm.
Okay.
Sure.
Mr. McNamee, are you looking for individual motions to approve these, or you want to do them as a group?
Should we do them individually or just all at once?
Individual.
I'm sorry, I missed it.
What's the pleasure of the board, I guess?
I would say let's go one at a time.
Okay.
I think it'd be appropriate.
I
So
make a motion to approve.
Mr. Weaver has a motion to approve.
And I'll second that.
All right, Mr. Wilt, all in favor of approval of the resolution number 1? 6-0. Perfect.
Okay, resolution number 2 is very brief. We still have a few outstanding OBOT applications, the office-based opioid treatment facilities, and so we're just hereby requesting an extension of the licensure date. We had previously extended it to October 31st. We're just asking for another month's extension in order to go through some of the outstanding waivers that we have, that we still don't have the inspection reports back for you guys to consider at this meeting, so we wanted to, so as to not disrupt access to care, just push that back until November 30th of 2017.
Okay, is there a motion?
Madam President, I move to approve.
All right, Ms. Riddell, is there a second to this?
Second.
Mr. Cassidy, all in favor? 6-0. Perfect, thank you.
Resolution number 3 talks about, it relates to OBOTs. We have been approached by several company, or well, at least one company that is seeking to perform detox in using buprenorphine products in jails for the inmates. This isn't necessarily long-term treatment. The protocols only exist of about 5 days of detox. It's based off of a program that's run out of either Oregon and or Washington, and the company hopes to head off any reactions that result from the withdrawal, so negative health consequences that result from withdrawal. It's not necessarily that the withdrawal is life-threatening, but the person that may be using may have other underlying health conditions that are exacerbated by the withdrawal, and so they're trying to essentially prevent those consequences from occurring by putting them on, putting them through detox. The question lies whether or not they fall under 4729-553, and so this would simply clarify that that detoxification does not fall under 553, because there are some issues with them meeting specific requirements in 553 because they're in a jail or a prison. And so we wanted to just make it clear that that would not make them fall under that, although they are all licensed as Category 3 terminal distributors of dangerous drugs.
I have a question.
Sure.
So this is stating that they can perform the detox, but they don't require our license, correct?
They do not require our office-based opioid treatment license. They still require our Category 3 terminal distributor license as an institutional facility, of which they are.
And 4729.553 is our OBOT.
Is OBOT, yes.
So I read this like 3 or 4 times over the weekend. Can we add the words meet the requirements? Wait, maybe let me read it a 6th time. For requiring licensure. So I guess to me, when I read this, I read it as they don't meet the requirements, which then therefore means I can't do it. Where if they don't meet the requirements requiring the licensure. Maybe that's just mincing words, but I was trying to figure out if they legally could do this or couldn't.
Sure.
Like just the word requirement for licensure right before the for requirement, or however you want to make it sound good.
Gotcha.
You do that well, but it confused me.
Yeah, sure, we can make that clarification. And I should note that we are seeking a statute change that I think we discussed previously that was going to go in the budget, just never made it in there, that the board would basically waive jails and prisons from all of 553, just because it's not necessarily the, one, they're already licensed with us, and two, it's not necessarily what we were trying to get at with office-based opioid treatment licensure. These are very highly regulated environments, and so they're not necessarily the for-profit clinics that we were very much concerned about that necessitating licensure. So this is, one, just clarifying that, but then two, following up with the law change.
If there's no other comments, I'll make a motion to approve it as amended.
All right, is there a second to Mr. Wilt with including such changes from Ms. Yarsh? Any other further discussion or concerns? All in favor? 6-0.
Resolution 4 comes to us from Hamilton County. They have been the lucky recipients of about 25,000 additional doses of naloxone, and they're looking for different ways to distribute it. They were hoping to seek some clarification and adjustment from the board to implement a program whereby law enforcement, if they are at this scene of an overdose and they administer naloxone, but there's a refusal to transport, that the law enforcement can provide on-site training and personally furnish the individual naloxone. Currently, the law exempts them from a terminal distributor license for the possession to administer, and this would take it one step further. That would, again, allow them to personally furnish. They would still need the protocol by which the doctor authorizes them to personally furnish on their behalf, but it would still allow them, it would allow them to be another avenue for the distribution of naloxone to high-risk individuals.
Question on that, Mr. McNamee, and this is more just an inquiry, not about the
Sure.
resolution. I'm curious if law enforcement is within this construct able to not only administer naloxone to individuals that they're being called to look after, but can they also administer it to their own? I mean, we're seeing this issue where exposure to products putting law enforcement at risk. Can they give it to their own law enforcement
Yeah,
people?
so the law does allow them to administer it in the event of an overdose.
Okay.
So that was already in statute a couple of years ago, 2013, in a previous bill. And so, yeah, they do have the ability to administer in the event of an overdose. It doesn't say who it has to be to, it just says they can.
Thanks. I would move to approve this resolution.
I have a motion for Mr. Pastuchino to approve. Is there a second? Mr. Newland? All in favor? 6-0. Continue, Mr. McNamee.
So I've had at least 20 phone calls with some very anxious sample distributors. And it had come to our attention that it was pretty near uniform that the sample manufacturers and distributors were not actually performing any verification of licensure. And this came about, obviously, when we closed the loophole for anybody that controlled substances on site. We issued guidance that basically said, okay, well, now regardless of what you're shipping to those doctor's offices, you have to verify that they're appropriately licensed, particularly as it relates to controlled substances. And in July, we did ask for a clarification from the board to create a modified process where they wouldn't have to go too deep into, at least when they were selling non-controlled sample drugs, and by sell I mean transfer, zero cost, barter, all that stuff. They would be able to just get an attestation from the prescriber saying that they are an exempted entity, instead of having to go through their background, their articles of incorporation and things of that nature. There has been some concern raised that these sample operators are and I've talked to a few of the larger ones, are requesting an extension to allow them to get into compliance. They are basically saying that right now they don't have a process in place by which they can meet the attestation requirements and or the verification requirements. And they had said, particularly there's one large system that a number of different providers use that they should have up and running, they told me, by April 1st of 2018. And so as to not impede access to people getting their samples, the prescriber's office getting their samples, we're just requesting that the verification as it relates to non-controlled sample drugs only, that gets postponed until April 1st of 2018 to allow for all the IT systems to come on board. This would, one, make a lot of folks very happy in terms of the clinicians so they could have access to their samples again, and two, prevent me from being on a conference call with every other manufacturer of dangerous drugs.
So Mr. McNamee, why can't these agencies perform primary license verification the same way we do?
Sure. So they have essentially been relying on, my understanding is that they have been utilizing the prescriber's DEA as a lot of them have been using the DEA number as a, basically being able to query against that to determine if they're appropriately licensed in their state, because they wouldn't have a DEA number if they didn't have a valid medical license. And so they had been using that as sort of a proxy. It's a little bit of a shift where they're having to verify the actual location, and it's tricky. It's a little tricky because prescribers by law have to request samples individually. So it's no longer like the office manager or whoever is responsible for ordering the drugs for that location. And so they were always under the impression that samples were somehow a different breed of animal. And so, it's my discussions with them haven't really focused on punitive, but more of educating them on what we expect them to do, including their agents. So they use a lot of, obviously, sample reps to perform these activities. And so in order to meet the documentation requirements and to develop the processes that we set forth in July, they are basically asking for some time to come into compliance, because there are a number of places that say they're just going to stop shipping samples until they can get on board. And so the decision then has to be made whether or not we want to preclude non-controlled sample drugs from getting out there, or whether or not we can give them some time to sort of come into compliance.
Is there a motion?
I'll make a motion to approve.
Mr. Wilt, is there a second? Seeing no second.
Wow.
Believe we're going
4 for 5.
to give this back to you, revamp it, decide, and if the motion's dying due to the lack of that second motion for support. Thank you very much.
Okay.
Moving forward.
Thank you. All right. Let's move on to, you should have a document. You'll have a packet of the technician roles. That's more for your own clarification, but I wanted to actually go through the document that says proposed changes to technician roles and just give you an overview of some of the proposed changes to the tech rules that resulted from some of the comments we received from the public rules hearing that we got in or we had the public rules hearing actually on the 2nd of October. And so I'll take you through these proposed changes, and then there are also some outstanding issues on the next page as it relates to the technician rules. And then I guess we can kind of vote them out as a package. So 4729.3.101 definitions. In order for us to only have to update where different versions of USP once, we basically want to put them in the definition section and then just reference those sections, reference that in the later rules. And that'll be helpful because we can easily update definition sections without having them to go through CSI. So 3101 would just add the definition of USP 797 and 795 to the rule. This obviously is in reference to the required training for non-sterile and sterile compounded drugs that we require in subsequent rules for trainees, registered techs, and certified techs. The second bullet is to clarify that support personnel can document and process third-party billing information for reimbursement. It just said that they could document third-party billing information, and so there was just clarification requested that support personnel could perform the processing of third-party billing information for reimbursement. Any questions on 4729.3.101? 4729.3.201, registration procedures. Some minor grammatical cleanup. There were some references to as defined in. We changed those to accordance with in those 4 paragraphs there. That was really the only change in that regard. 4729.3.203 has to do with criminal records checks. There was a reference to the web check providers as it relates to processing of ink impressions, and that shouldn't be there. That's obviously the ink impressions can be done, particularly for if somebody's there's basically stipulations in the rule that says if they're coming in from out of state, much like those through reciprocity, and I don't think there will be anybody really doing that, but if they do, for them to they could use ink impressions, and so we don't want to limit it to web check providers because those are meant for people potentially coming from out of state. So like, let's say they graduated from an ASHP program and they were trying to come into Ohio to get licensed, they could get their fingerprints rolled before they came here and apply for registration. Paragraph D, also, we did discuss the whole validity of the criminal records check last month as it relates to interns and pharmacists, and we just wanted that paragraph D was modified to make sure that the criminal records checks were valid for 1 year from the date the results were received by the board, which is the same for interns and pharmacists. So we just wanted to make that all standardized. Any questions on 4729.3.202? 4729.3.301, we just moved the period inside the quotation marks in paragraph A of the rule. That's about it. 4729.3.302, this probably got the most comments during the rule hearing process. The proposed changes to this rule include reducing the number of hours of didactic training from 80 hours to 40 hours. There was a lot of concern, specifically on the didactic training, not necessarily the experiential training. And then, as a result, though, also moved the 320 hours of didactic training that was previously approved to 300 hours. Sorry, this should be experiential training. So going from, and before, we had previously discussed maybe splitting the difference and going to 60 to 280. So here we just went down to 40 for didactic, but then up to 300 for experiential. And that number of didactic hours was the number that was requested by the Ohio Pharmacists Association. We also there was a proposal to remove reference to anatomy and physiology in the didactic training. So before it said pharmacology, anatomy, and physiology. We left pharmacology in there, but there was a near universal suggestion to remove anatomy and physiology from the didactic training. And then because of the advent of online tests and that we do allow for evaluations and coursework to be done either remotely or in person, sort of a blending learning model, there was a removal of the proctor requirements for the didactic testing piece of it. That still doesn't mean there's still a safety net there in terms of the board has the ability to adopt testing policies that the didactic evaluation components will have to meet. So if we're seeing any issues, any kind of funny business there, we can still go through and implement some policies regarding testing. So those are the proposed changes to 4729.3.302. Any questions? Concerns? 4729-3303, registered pharmacy technicians. So all specific references to USP were removed from the rule, and that just means instead of saying 797 version da-da-da-da, we just reference back to 797 in the definition section, which gives you the specific version that we're expecting folks to adhere to when it comes to the training. Because we've had this very robust discussion about USP 800 and whether or not we actually want to move forward with it, and the fact that it was delayed, we probably don't want to make all the technicians have to adhere to any of the training standards in USP 800 if we as a board have not actually adopted USP 800 as our hazardous drug training standard. And so we will obviously look at that as part of our review in the ad hoc compounding committee as well. And that could certainly be another chapter or another rule we add when it comes to the handling of hazardous drugs. We'll talk about that third bullet point about refills to requests to be sent via electronic or fax requests. We'll talk about that on the next page. Any questions on 3303? It's kind of a mouthful. All right, 4729-3304, certified pharmacy technicians. We corrected an incorrect cross-reference in paragraph B2C of the rule. Again, all references to specific versions of USP were removed. Again, referencing back to what was in the definition section. 800 was removed in terms of the training. And we basically just, where it talked about what pharmacists could accept new written electronic prescriptions, we also just, as we clarified, or as we authorized last time we met, to allow them to accept new verbal orders, we just made a reference that they could accept new verbal orders as long as it met all the conditions that we applied there. And that was really more for clarity's sake as they talk about what they can accept in B1. We just wanted to make sure that they just have to make sure to go down to B13 to know how the technician, certified technician, may accept new verbal orders. Any questions on 3304? 4729-3401, disciplinary actions. There was an incorrect cross-reference in paragraph B that was corrected. And then in terms of the definition of dishonesty, we removed the term pharmacy and just replaced it with licensed location. Because there obviously are pharmacists operating in, let's say, an outsourcing facility or some other facility like that. So we just made it more broad in terms of licensed location. 4729-3401, duty to report, we just corrected an incorrect cross-reference. 4729-3501, continuing education definitions. The issue here is we got a little ahead of ourselves. We have some CE rules that are moving through, and this specifically referenced those CE rules, but we can't promulgate a rule that references a future rule. So we referenced standards in general, and we'll be able to go back and clean that up. But we'll still hold them to whatever new rules we adopt. It just will be, we just can't make specific references to those rules. And that mainly had to do with board approval of a in-state provider for the free clinic work that the law requires us to offer them 1/3 of their CE to be able to do if they're working there. And then 3502, there was a reference to a certificate. I'm not sure where that came from, so we removed that in paragraph A. And then again, we removed any references to those future CE rules where they're going to be. So we just made it more of a broad reference. So you'll find in some of our rules we do use the phrase agency 4729, which basically holds them to our entire rule chapter as it relates to specific subjects. And then as we reorganize and get a little bit more settled in our divisions, there'll be more specific references coming through and updated. So those are, any questions on any of those proposed changes?
So I have a question regarding the refills to be sent via electronic fax or requests.
Yes.
You added it to be applicable to registered pharmacy technicians, and obviously it was already in the certified pharmacy technicians. I guess my question is, first off, we're using the word refill request two different ways in the rule. If we go under 4729.3-101, we discussed that support personnel can submit refill requests at the request of the patient.
Right.
So I guess my assumption of that understanding is I can call in, talk to support personnel, and support personnel can refill my amlodipine.
Basically like a foam tree.
Right, but then we're using refill requests to a prescriber differently. And I guess my question here is if I'm allowed to tell a support personnel I want my amlodipine refilled and it has no refills, the way we've drafted this, that support personnel can't hit send and send an e-fax to the doctor. Or can they?
So currently they're not permitted to right now. The question came particularly from the long-term care where they do a lot of faxing to the doctors to make the requests. And that was a question that we got during the rules hearing, which wanted to discuss with you whether or not refill authorizations were permitted. And this is not necessarily, so basically it's more of a prescription renewal, a refill, the way that refill authorization is defined. So it means it's out of refills and you're just making the request for additional refills to be put on that. So basically you're requesting a new script, whether or not they want to authorize a new script, as long as the prescription remains unchanged. As opposed to, hey, I didn't do auto refills, I'm calling in, yes, then support personnel can certainly say this person wants a refill if they have valid refills left on their script. So the question remains whether or not we want to authorize registered techs to, particularly because it's been explained to me that it's commonplace in the long-term care world, to allow them to submit refill requests, whether or not we want to do it verbally, whether we want to do it electronic or by fax. My understanding it's done pretty commonly via fax.
I guess I'm a little further than you, and if we're allowing support personnel to refill my amlodipine because I'm not an autofill, why would they not be able to send an electronic request to my physician to get it refilled that would come back to a registered certified technician? So I'm guessing, I think we need to allow our support personnel to do that because that's very much a support task. Hey, I need this refilled. Oh, I'll send a fax to your doctor. The doctor will then respond and it will go to a pharmacist, a registered technician, or a certified technician.
Yeah, I think any of the technicians should be able to send a request, whether it's fax or hit an electronic button.
Okay.
I thought we had talked about that the certified technicians, not the registered, will be able to accept that refill authorization from the doctor.
So, Mr. Weaver, I'm a step further. I think support personnel should also be permitted to request it.
Yeah.
Yeah. So not a tech.
All of them.
Because we have support personnel, which is a register or a phone operator. We have a registered tech, which is employer-based training. And we have a certified tech, which passes a nationally approved exam.
So the only distinction would be, do you only wish to authorize them to make the request via electronic, verbal, or fax, paper means, or do you want everyone to be able to make the request? The acceptance part. So for instance, certified techs accepting or requesting refill authorizations for dangerous drugs that are not controlled substances from a prescriber or the prescriber's agent, so long as there's no change from the original prescription. So I guess, do you want them to be able to make the requests, or
I guess in
also
terms of support,
accept the new prescription as well?
Well, accepting at this point must be certified. Currently, as written, certified can request verbally or electronically a refill. Registers have to be electronically. Am I reading that correct?
I don't.
In 303?
Right now, there's no corresponding accepting or requesting refill authorizations for registered technicians.
I'm sorry, will you repeat that?
So there's no corresponding accepting or requesting refill authorizations in 3303 for registered technicians.
you added it. Bullet number 3 under 3303 on your my little cheat sheet.
Yeah, that's why I told you to disregard that, because it's.
Oh,
yeah.
I thought you were telling me to disregard it because you wanted to talk about it.
Yes.
So you're telling
We
me
are
to disregard it because you don't want to put it in.
No. It's one of those. It's one of those outstanding issues that.
Oh, so that's a couple pages from now.
No. None of this is my opinion about what goes in and what doesn't go in. One is, this is to add a completely new scope to their scope of practice. So.
Okay,
it's
so
it's up for the board's discussion, how you guys want to handle it.
So I guess I want to add that bullet in for registered texts.
Okay.
And I also think we need to add it for electronic requests under support personnel.
For requesting.
For requesting. On support personnel, requesting only, electronic only, whether electronics, fax, or e-script, I don't care. But I don't need, an 88-year-old grandma calling saying amlodipine. I mean, we need some level of knowledge, so I don't think we need to make it verbal.
So just to clarify, you would like support personnel and registered techs to be able to request refill authorizations for dangerous drugs that are not controlled substances or controlled substances.
I don't know if it really matters because we're sending it to the prescriber. It has to come back to a certified or pharmacist or intern.
So in terms of, requesting refill authorizations for dangerous drugs from a prescriber or prescriber's agent, so long as there's no change from the original prescription, and you want to restrict it to written or verbal requests, written or electronic requests, or all three, where you just call them up.
Didn't we originally create this support personnel for that volunteer or that person that just comes in the pharmacy unpaid that helps ring register or do support things versus the activities of a registered or certified technician? It seems like we're expanding that a little bit to now there are going to be persons that are working the computer system or actually helping in the process of filling prescriptions.
That's what we typed a couple months ago. We typed submitting refill requests at the request of the patient. Doing third-party billing, so it's kind of broad already.
Yeah, so some of the support personnel were added at the request of call centers and other things that some institutions have. So I mean, I
Now
guess
we're
the
creating
question
it as
is,
a third classification of technicians in the process of filling prescriptions, it seems like.
Say that again?
I said now it seems like we're expanding the support personnel technician as a third class of technician that's helping in a process of filling prescriptions, where I thought initially it was just a sort of a cutout for that person that helps bring stock into the hospital pharmacy, or the person who sits at a desk and does billing but is not involved in prescription filling and processing, or the volunteer at the pharmacy or hospital that just comes in and rings register. That's not even a paid person, but we wanted to give them a title so they could be in the pharmacy. It seems like now that's getting expanded as a filling technician, which I thought originally that was the registered technician and the certified technician.
and just to clarify, the request didn't come, the discussion I had was not that it should be support personnel. It was more talking about the registered technicians and whether or not they could make those requests, typically via fax or electronic. Because the flip side is if they're able to make verbal requests, then they're accepting a new prescription. And then do you want them to be able to accept? Because right now the laws basically reserves that right for certified techs.
To accept,
for
but not
non-controlled.
request. The request should be the certified order registered technicians. We agree on that, right?
Will you repeat that, Fred?
We agree on the requesting a refill authorization. Requesting can be the registered or certified technician in whatever form, whether it's a fax or electronic or a phone call. But an example of a phone call, if that authorization is granted, it needs to go to a pharmacist or a certified technician. Now, taking a paper off a fax machine, if that request was approved and signed, I mean, that's not the act of accepting, that's just taking a paper off a fax machine. Isn't that where we?
I would agree with that. A certified can do verbal or written. Right. Registered can do written or request verbally, but not accept verbally.
Correct, but the support personnel, that extra person that's unpaid, that we just wanted to give a reason that they're allowed to be in the pharmacy or do billing, I don't know that they need to be involved in the process of workflow and the filling of a prescription.
I actually wouldn't disagree with you, although the way the rule's written today, if we're going to allow them to accept a request and it has no refills, we need to allow them to send the request. So to me, we either, if they're allowed to answer the phone and say, I want my amlodipine filled, they either need to be able to request the refill or they need to not be able to accept that phone call at all.
The support personnel.
The support personnel.
They shouldn't be doing anything.
But in terms of a call center where they're just answering calls, that could be problematic because it's just a call center and they're saying, will you fill this drug? My name's Sean Wilt, here's my birthday. They're not really doing anything.
Well,
right, that's different than requesting a refill. That's just accepting a phone call. He's talking about requesting additional refills on prescriptions out of refills from a doctor's office.
But hitting send to doctor does not require any professional judgment that they already haven't done.
Right.
If they've answered my phone and said, my name's Sean Wilt, here's my birthday, fill my amlodipine, they either hit fill and it pops into my technician's queue and they fill it, or they hit send to physician. It just really depends which button they
I think we should keep the two classifications of technician and just still leave the cutout to allow those support personnel, not full employees in the workflow. We're expanding that to 3 classes of technicians.
Yeah, I feel like what the discussion
Going too
is,
far.
from what I'm hearing, is that there is different ideas of what these support personnel are supposed to be in the pharmacy, because you, with your practice, is more register-based. You're having somebody come up to the front to help you ring up prescriptions, telling people, do you have any questions for the pharmacist? And then just you got IC3, let's go, let's get people out of the registers. While Sean is seeing, I'm hearing it's more of like a call support center, which is kind of where I'm seeing my support staff. They sit in a room, they answer all the phone calls that come in. If that technician is able to have access to that medical chart or medical record or that dispensing software, they have access to all of that information. And they should be able to press that button to say, yep, looks like we'll go ahead and I'll fill all of these. And a lot of our systems will just shoot those off to the doctor immediately. So as soon as you tell that computer system to fill, it shoots it off immediately anyway. So I think that's where everything is kind of, where we're not understanding as to what that whole support versus registered and certified. We get that. I think it's the support personnel that we are having issues with. And whether or not do we want to have our call center people be registered technicians and such.
Because I guess my concern is if they answer the phone and say they want it and there's no refills, for us to send them through a phone tag where they finally get to the right person, eventually the patient may hang up out of frustration and therefore become non-compliant, therefore impacting their health outcome. I don't want to create an obstacle because Susie is allowed to answer the phone, but just can't take that simple request. So it's either we allow them to not do it at all, or we give them the ability to do both pieces.
So this is a question, to just fill my ignorance in. Today, in our retail operating systems, if I call in and request a refill that does not have refills, doesn't your system automatically ping the physician with a request? Doesn't the system generate a request out to the doctor?
Yes.
So I'm not sure why this is different. If we're allowing automated systems to automatically act on my behalf as a patient, I would think we would want to encourage, or we would want to allow support personnel who are functioning no differently than your computer systems to also send a request out to the physician's office. I'm not seeing the difference there in my head. So I would be okay with the support personnel processing an electronic request out to the doc, since our computer systems do it automatically anyway. I don't see that to be different.
It's the pleasure of the board.
I would include the rule update to include support personnel to request electronic versions of refills into physicians' offices.
Mr. Wilt, or Mr. Pacifium.
Call me Fred.
The other question was whether or not they could send a fax as well.
You're going to have to speak up.
So the main request was actually regarding faxes, whether they could send a fax request.
Once again, that's hitting print off of a screen
Sure.
Right.
and walking to the fax machine and dialing. I see no professional judgment other than they may misdial, which is the same thing you or I could do.
I would include it.
Is there a second?
I would second that.
Mr. Wilt? All in favor of the motion? 4? All opposed? I got 2. First passes. Thank you.
So if you look on the next page, here are some comments I just wanted to bring to your attention that we received during the public hearing. Particularly the hospitals, the Society of Health System Pharmacists raised the concern about the issue around stocking dangerous drugs and retrieving those drugs from inventory as a burden to the hospital systems. And so they were requesting that the support personnel also be able to stock and retrieve dangerous drugs from the inventory section.
Focus on touching drugs.
So the OSHP was talking about how potentially for the hospitals it might be a worker issue to not be able to have what they refer to as, in their comments, unskilled laborers, to be able to stock dangerous drugs and retrieve those drugs from inventory. And as you're reading the comment, it says the effect of requiring businesses to hire pharmacy technicians to complete tasks that may have been traditionally executed by storeroom clerks, materials management, or supply chain was not specified in our business impact analysis.
I'd like to hear from my OSHP.
Yeah, so just a couple of questions around, and I've not spoken to anybody at OSHP about this specifically. I think we talked about this at length the last time this rule came up. And I think, if I remember right, where we landed was if somebody wants to move drugs from a receiving dock to the pharmacy and make a drop, that could be support personnel. From the time you take products into the pharmacy and begin to push them into locations and stocking shelves, whatever the case may be, I thought we landed that that would have to be at least a registered technician. And correct me if I'm wrong on that. Connie and I were talking about this. There's also the issue of, in some organizations, IV fluids that, by the nature of their construct, are considered drugs by our definition. We have to be careful with that one because we would need to understand how that's handled in the definition. Because I think there's a lot of health systems where you have non-pharmacy personnel moving IV fluids around hospitals all the time, and they're nowhere close to being pharmacy trained, certified, registered, whatever the case may be. So I'm not sure exactly what the organization was speaking about here, if it was about anything considered a drug with an NDC number on it, or is it specifically products inside the pharmacy, the licensed space?
Their biggest concern was basically, my understanding is moving it from the loading dock to the actual pharmacy itself.
Which should be secure, locked, toted. I get that. I'm okay with that.
Right.
Once it crosses the threshold of the licensed space, I think we need to have somebody that we have licensee, some type of licensee that we can actually hold accountable to how that moves
I mean, they
forward.
did also have an excellent point about moving medical oxygen as well, because technically it falls under
As a drug?
As a drug, because it
We may have to consider oxygen and IV fluids at some time. We just have to understand what the scope, because you're going to get these questions bouncing back.
Well, and I guess that's the question. We can certainly draft language where it cuts it off at the pharmacy, or, so they're not necessarily in and out of the pharmacy.
I would float that language by OSHP and see what their thoughts are there, but I can tell you that pharmacy personnel rarely, if ever, touch medical oxygen.
Sure.
Right.
we'd have to carve that out anyway. And there is a number of IV fluids that are also going to be in this same, I'm not sure about your organizations, then you have imaging contrast. That's considered a drug. Many times those do not pass our thresholds. And we could change that, but there are some very specific health system things that we need to be careful with. Products that come into our centralized warehouses that are legend drugs as part of kits, surgical kits, or whatever the case may be, we never see those. They go into central supply, never pass through pharmacy, and go right to a surgical area or procedural area,
So if we made the cutoff actually in the pharmacy?
I would.
Because I think that was our discussion last time was, okay, they're putting the drugs away, they probably should know what they are, they probably know where they go.
Yeah.
We don't want people who are untrained to be doing that. And so that was really the main discussion there, was in the pharmacy, access to the pharmacy, that kind of stuff, so.
Do you think I'm not sure they're coming down on this one.
I would say that if it was going to be dispensed through the pharmacy supply chain, through the pharmacy, that might be an easier way. We receive all the contrast, and currently we distribute all of the IV fluids, but that's going to be changing here shortly. But there are many different things that come in and that would be classified as a dangerous drug that would never cross my threshold. So I don't know how you can word that language that unless it's, or maybe perhaps only things that are dispensed through the pharmacy supply chain. Not necessarily stored within the confines of the pharmacy, because it might not, we might be responsible for it, but it might not come to me, if that makes sense.
There's the whole issue of how you're going to handle the hot labs. Those are all dangerous drugs. I'm not sure if we carve those out in our definition, radiopharmaceuticals.
Right.
Right, and which most people aren't authorized users, so we can't handle them, so.
So why don't you try that language with
Okay.
Bob or with OSHP and see if it came out of the legal division. I'm not sure what division put that forward, but, and see where they land on that.
So the next three comments we received had to do with the approved pharmacy technician training programs, 4729-3302. There was a request by Stark State College to allow non-employer-based programs to meet the employer standards. There was a request from NECDS to reduce the required examination questions from 100 to 90. The rationale being that 90 is the amount of questions that's on the PTC, should say PTCB exam. And then there was another request from OSHP to allow non-ACP accredited training programs until January 1, 2020. I think we had required accreditation because basically we can't really control what these schools do. And so that was the general rationale for pushing towards accredited programs, to make sure that there are some training standards in there. So they actually have to follow certain standards that we were going to get out of the space of, approving all these programs. So that was the rationale for moving towards the ACPE standards for the school-based programs, just because we're not necessarily in that space now.
A pure employer-based training, so not ASHP or ACPE or PTCB, pure employer-based is not transferable between employers, correct?
It is.
Okay.
Cameron, why would an employer-based program be transferable between employers?
The only thing that's not transferable between employers as it relates now is that the compounding training is, the rule requires them to do the compounding training. if they're not within the same employee. So like if they went from one Meyer to the other, then that would be fine. But if they went to Meyer to Giant Eagle, then they would have to retake at least the compounding training. The thought process, the rule also does require them, and it puts the onus on the RP to make sure that they have additional site-specific training related to their environment. So the goal of the training standards we laid out there was to give everyone sort of a base level of knowledge and experience, because once they're registered, then they could, or certified, they can move around. It's a portable license, much like an intern's license. So that's the thought process there. And then they're also getting CE, so they are still required to maintain CE to maintain their registration or certification.
Board members?
I will.
Feel free. Yeah, go ahead.
We're talking about the transferring of the tests. If it's a test that the board does not see or approve, I don't know.
So we're not necessarily talking about the test. We're talking about whether or not we let, you know, this college, that college, those fall under what we consider approved training programs.
So,
and then whether or not we want to make so there's a required employer test, employee-based test for the didactic evaluation. Right now it's at 100 questions, which I think we took from Florida. There was a recommendation to move it to 90.
So I'm okay with the move to 90 if that aligns with PTCD. I get it.
I mean, they still have to take PTCD.
Help me understand the part where OSHP is saying recognized training programs certified by the Department of Education or approved by the Ohio Board of Regents. Is that, what does that mean? Is that high school? Is that college?
No,
what is that?
Those are sort of accredited. Those are colleges and universities that are recognized in the state. But they're not ones that are necessarily recognized through ASHP and ACPE as approved training programs that have met the accreditation standards. I will say I've met with talked to at least three schools that have already started the process of moving to be accredited. And the thought process behind accreditation was to have another avenue, but sort of remove it from the board. I mean, put it into this accrediting body so we don't necessarily have to get involved in sort of the oversight of the schools, much like we do now with the accreditation of the pharmacy schools.
So if the Department of Education or the Board of Regents approved a college university, does that mean that they have already by default met university accreditation standards by people that accredit universities, not that
that just means that there are sort of institutions of higher learning in the state. It doesn't have anything to do with the quality of their pharmacy technine training program.
Okay.
Which is why
or any of their curriculum, or that
right.
matter, right?
Which is why we're requiring, you know, and these also can include some of these for-profits that charge people an arm and a leg to become certified. So the thought process was to put in place this ASHP standards if they're going to move outside of the employer-based model. So we know that they're getting quality reviewed education as it relates to being a technician.
And I'm assuming the board has no appetite to get into tax incentives. I'm assuming that, but I guess we should ask the question. I'm not sure it's our job to incentivize development of programs. I think they will have to come into the marketplace and let market dynamics play out. But
yeah, and I think certainly, you know, the employers should have if the concern is about workforce, they have a year and a half to get a program up and running. So, because right now there's a sort of a grandfathering period where they're allowed to meet sort of the old training standards and move to the new training standards. And so if there's a concern about workforce, the employers know, here's what they've let out, here's what the board's laid out in terms of expectations. You know, the other thing is that for the PTCB folks, if they pass the PTCB, then they waive the didactic portion and they just go right to the experiential, which means they're working for you anyway.
I just think that if we further delay implementation, we're not going to let the market develop and evolve. You know, as an employer, we're working on meeting this deadline already, which is causing us to accelerate our discussions, which is a good thing from my opinion. And we just cut the didactic hours in half again.
Right.
So I don't think we're asking too much to come up with a 40-hour didactic program in the next year and a half. That seems to be reasonable to me. I'm not sure I want to extend it any more beyond that.
So in terms of those 3 items, is everyone good with moving from 100 to 90?
I guess I'm stuck again. And I thought we unstuck me 2 months ago.
Oh boy.
But this different standards that different groups are having to meet is very confusing. Because we now have an employer-based program, which we've reduced. And now, I guess I didn't understand that the employer-based training could be transferred. And so I question, in 40 hours of didactic training, I envision an hour and a half of HIPAA, an hour of fraud, waste, and abuse, 30 minutes of meth check for PSE, 30 minutes of Accutane training. And there's all this training. And in the end, eventually I'm just going to train them how to work in my either corporate pharmacy or the independent pharmacy. And is that employer-based training going to be too narrow to be transferable? And the standard, because we're not evaluating it other than following the rules, I guess I don't get why Stark State College's standard would be any different than ours if they're following our rules. And I mean, for Stark State College, obviously it's very expensive because when I pay somebody for 40 hours of training, they're following 300, they're productive for me. Where these students are going to be paying for 300 hours to volunteer at a pharmacy. Our standards just are, every kind of organization has a little carve out, and I'm concerned about the transferability of that knowledge base between those carve-outs. And if we have accomplished what we've designed, which is to raise the level of quality.
So I think it's important to recognize that even at 40 hours, we have set a minimum threshold that far exceeds pretty much every other state. Most states, Delaware only makes you get 10, and then you get registered. Some states just make you pass the background check, and then you get registered. So, you know, I think we were just trying to figure out, as it relates to a good portion of folks are entering via the employer-based training, probably from the retail sector. I can't speak for the hospitals. So we were trying to, you know, make it clear that, you know, here's what our expectations are. Here's setting a minimum threshold of what we want to see. In terms of going outside the scope, in terms of these colleges and universities, we just don't have the time or, you know, people power to sort of police these individuals and police these programs and make sure they're up to snuff. And so that's why putting the accreditation onus on them, that's up to them. And so where we do have the stick and we do have the oversight is the employer. And so that's where we can certainly, you know, either we could do audits, we could do reviews. I mean, we could certainly still do a bunch of, I mean, Terry's not going to be approving everyone's tests now, so we've got time to sort of review programs in terms of quality. You know, that the thought process again is, you know, trying to find some minimum threshold of training that we would feel comfortable that they get a very base level knowledge. And, you know, obviously we're pushing everyone to certified, so in addition to that, they're going to be studying for PTCB. So we are trying to push people towards the certified aspect of it as well. So, I mean, I get what you're saying. I think it's just...
Actually, you said one thing and you sold me. Because as an employer, you license me as an
Yes.
employer, so you have responsibility. You don't license Stark State College,
No.
so you sold me. And I truly do believe the most beneficial training is going to be the 300 hours of practical training,
Yes.
not sitting in front of a computer. So you've sold me, I'm unstuck.
So.
The last one of you in the room gets a prize.
Oh, wow. There were a lot more people when I started.
So do you have what you need on 3302?
3302, yes, generally, I think I've got it. And just to let everybody know, the timeline for getting these locked and loaded is we've got an electronic application all ready to go. It'll totally be online. It'll totally be paperless. And we, obviously, having to register an estimated 42,000 people in 6 months, we're certainly going to wait for these rules to get to sort of the point of no return, but obviously open them up in early November, which is why we're trying to get everybody all squared away right now. But in terms of 3303, we already talked about refill requests, so that's a non-issue. And then, obviously, we already discussed this, but there was another request to remove the CE for technicians. But it is pretty commonplace in other states, and as we've reduced the didactic hours, it's probably good if we maintain certain levels of CE across the board.
Mr. McNamee?
Yes.
There has been a request from many of the board members at this moment to take a quick 10-minute break. We've been going at it for
Request
about...
denied.
Request is not denied. I've got the gavel. If we can just reconvene here around 3:15, we're just going to take a quick break, maybe stretch our legs, maybe cool down a little bit. We can walk outside. I know it's getting a little warm up here underneath all the lights, so we'll come back here in about around 3:15.
Okay, so before we adjourned, I just want to quickly go over the additional requested changes. So we're going to look at language regarding dispensing through the pharmacy supply chains in terms of stocking drugs, reducing the examination questions from 100 to 90, and then also, well, those are the only two changes that are resulting from those comments. Other than that, we have all the other changes on the front page that I would need a motion from the board to incorporate into the rules for refiling with the Joint Committee on Agency Rule Review.
Mr. Pacifium, is there a second to that motion? Yep, the motion was to accept the changes as discussed for the
Yes.
technician rules
Mhm.
that are laid out.
Discussion. I would like to make I don't know if a motion is appropriate, but clarification and see if we have the board's support or thoughts on this. Amendment? Thank you. Support personnel, not to keep beating this down, should not be involved in the act of filling a prescription. And if support personnel are sending refill requests to physicians by electronics, the fax machine, the telephone, that they are in the workflow of filling a prescription and acting as technicians. I would like to get that clarified and fixed as far as the definition of a support personnel. In my mind, a support personnel was that volunteer that's helping out in the pharmacy unpaid, that we are able to give them access into the pharmacy, but not access to the act of filling a prescription and the workflow of filling a prescription. Comments or concerns?
Any other additional questions or discussion to that?
So, Mr. Weaver, you're asking, or your opinion is that they should not have access to either the electronic record or the dispensing system in a retail setting. They're strictly there to ring out the register or help whatever.
Right. External support.
Ancillary duties.
Not support in the act of filling a prescription, access to HIPAA information, person's files. If there's a business model out there that needs that, then they should be a registered technician.
Isn't billing part of the support personnel? If it is, then that might be a problem, because I would assume that they're going to need access to a dispensing system for the process of billing.
I don't know, I don't personally know that billing, and I would assume that's going to be in a hospital or a nursing home or a different setting, has specific access to that information. I don't know, you tell me. But the part I'm concerned about is the support personnel in the access of filling a prescription, which would include sending for refills. Now, if there's other business models that I have not worked in or the experience in, please explain on why that would be necessary as our definition of support personnel and why we initially added support personnel in addition to the persons allowed in the pharmacy, pharmacists, registered technicians, and certified technicians.
So, Mr. Weaver, in your proposal here, a company that would be operating a call center where they would be taking calls and requesting refills, either from the patient or from a physician, or doing any sort of clarification. You're saying at this point we require a registered technician or certified technician, so call centers and
Yes.
remote processing centers would all be required to be staffed by techs.
In my mind, that is a technician, not a support personnel that came in as a volunteer or very limited time to help over a hurdle to have access to the pharmacy. To me, that's a technician and it's employed in the process of filling a prescription.
Can I just clarify, and this may be the issue where it says submitting refill requests at the request of patients. The whole purpose of this was one employer in the state of Ohio had made the request here that basically the patient would call in and say, I have, 2 remaining refills, just like a phone tree where they enter the number in there, and that just gets immediately transferred to to fill the prescription. It gets transferred to the pharmacy. So that's not going to any clinician in that regard. Just want to clarify there. That's really what the intent of that initial language in support personnel is. So they're just basically acting as that phone tree system. So, and then to further clarify, the request was made from a licensee to allow the registered techs to make electronic or written or whatever refill requests of prescribers and prescribers' agents. So I'm just letting you know kind of the rationale behind why this was brought to you.
So on 4729:3-1-01, 01A, last sentence, submitting refill requests at the request of patients or any other activity as determined by the board, personally I feel should not fall under the definition of a support personnel. That should be underneath the technician, that's registered or certified technician. And I do agree that a registered technician should be allowed to put out refill requests in any form, fax, phone, but the accepting of that approval for that refill request, as we discussed, would be the certified technician.
I guess another way to look at this would be the access of PHI. So to me, a licensed individual or registered individual is the one accessing the PHI, and I don't know if support personnel would fall under that. I don't know if that's just another way to try to determine what's support personnel because they're accessing PHI other than a cash register. Because to Mr. Weaver's point, to me, support personnel is somebody coming in that is an untrained individual that may be running the cash register, may be, according to this, ordering the drugs or accepting a delivery but not putting anything away. I still stand by my original thought, though, that if we're going to allow the last sentence, we need to allow it the way we modified it before. But at the same time, to Mr. Weaver's point, the accessing of PHI and actually requesting a refill, whether it's from a physician or a patient, is a technician duty.
Cameron, just as a point of clarification on what we had a motion on and passed earlier for the 47-3-3-03, we approved and that to allow registered pharmacy technicians to allow refill requests, correct? So that was not, we did not vote at that point for support personnel, is what I have on my notes. That passed 4-2 earlier, is that correct?
My understanding that it was the motion, Mr. Wilt, to allow support personnel and registered techs to request refill authorizations for dangerous drugs.
So that was the motion to, my notes. So support registered technicians and certified technicians to allow refill requests via electronic and fax requests. Is that correct?
I think it was via any.
Okay. So I'll
method.
I think we need to move the conversation forward because this has already been discussed, from my understanding. Or is there a motion to rescind that motion?
I guess Mr. Weaver's challenging that motion and vote at this point for rediscussion.
Okay.
Is that correct, Mr. Weaver?
Okay. So it's your motion to amend or rescind said motion. Is there a second to that motion? So, Mr. Newland? Any further discussion that is necessary to rescind the original? So I'm going to then call for all those in favor of rescinding that motion. Got a 5, all opposed to 1. Okay. All right, we are rescinding that original motion and opening discussion again. And is there another motion to be had, to be discussed?
I make a motion that on 4729:3-1-01, parentheses 1, parentheses 8, last sentence, submitting refill request at the request of patients or any other activity as determined by the board be omitted, as to where support personnel may not access PHI information and act in a process of requesting refills on behalf of the patient.
Would you remove or any other activity as determined by the board.
I'm sorry, can you say that one more time?
I said, would you simply remove submitting refill requests at the request of the patient, or would you maintain or any other activity as determined by the board?
No, I think it would be appropriate to keep any other activity as determined by the board for future considerations.
Okay.
Mr. Weaver, I would like to ask if we would rescind the part related to PHI, simply because if they're going to access the system for third-party billing information, they are going to need access to some PHI.
Okay, I agree. Thank you.
Can we restate the motion then, just so we're all clear? Sorry. Can we restate the motion then without, it was with rescinding the PHI, is that correct?
Correct.
So you would like 4729:3-1-0101 to read as how? Just striking the last.
Striking submitting refill requests at the request of patients.
Is there a second to that motion? Ms. Yarsh? Is there any further discussion? All in favor of the motion? 5. All opposed? 1. Motion passes.
Do we also need a motion to authorize registered technicians to make refill requests?
So under 4729:3-3-03?
Yes.
Okay. So looking at that one, that is your ask for the board if there would be a motion to accept that as registered technicians to allow refill requests. Are we under that understanding? So is there a motion to support that registered technicians can allow refill requests? All right, Mr. Weaver, you're going to make that motion.
I'll second that motion.
Mr. Wilt will second that motion. Any further discussion on that? All in favor of the motion? 6-0. Continue, Mr. McNamee.
So, not to get more complicated about it, but 4729:3-304 currently only allows the accepting of refill authorizations for dangerous drugs that are not controlled substances from a prescriber or prescriber's agent. Do we want to break out accepting and requesting to be two different activities? Or, because currently, I think what we approved for 3303 just says they can make any refill requests of a prescriber or prescriber's agent, as long as there's no change in the original prescription. So, but there was no limiting language about controlled substances unless that was the intent of the board to include controlled substances, a limit on controlled substance requests.
So as it's written right now, a registered or certified tech can request it, but only a pharmacist could receive it because interns also cannot receive controlled substances. Is that a correct understanding?
Well, currently, the way I believe that we've amended 3303, it says they can accept, sorry, they can request refill authorizations for any drug. They just can't accept any of them. Whereas certified technicians can accept and request refill authorizations, but technicians are limited to non-controlled drugs for both accepting and requesting. So would the will of the board be to make the modification to break out accepting and requesting so that certified pharmacy technicians can request all drug refill requests, regardless of controlled or non-controlled, but only accept non-controlleds in terms of refill requests? Clear as mud.
Clear as mud.
So then, rolling that all into all of the modifications that we've discussed, I just need a general motion to be able to file all of these rules as amended with the Joint Committee on Agency Rule Review.
Hold on. Wait, I'm sorry. One more question.
Discussion.
So accepting, especially if it's coming via electronic or fax back to us, then why wouldn't a registered technician not be able to receive that? It's only via phone that we would not want that to happen, correct? Like a verbal order?
I would echo Mr. Passafume's statement earlier, if a computer's doing it, a computer's doing it. So,
Somebody still has to type it.
Jen, can you say that again? I'm sorry.
So the accepting of a refill request back, if it comes back via an e-scribe or a fax back, either a registered technician or a certified technician should be able to process that.
Yeah, process it, but I don't think we consider the person who takes a piece of paper off the fax machine or turns the computer on as accepting it. I think that's automatically accepted into the computer system. I don't know how to word that, but
the EPS system accepted it.
So
I wouldn't consider it.
Are we only concerned about really the verbal part about accepting?
Yes.
Because
Yes.
because any new authorized prescription would be a new written faxed or electronic prescription order, which is under the authority of the registered technician now. So I get what you're saying, because a new prescription for a refill is still a new prescription, which they would be allowed to accept via written, faxed, or electronic prescription order. So should we clarify that it's just accepting a verbal?
Correct.
I think so.
Okay.
Yeah.
That's where,
Do that.
yeah, I just want to make sure that's
Yeah,
clear.
well, that would be.
Mr. McNamee, you're looking for a motion to accept the rules with the changes as previously discussed, is that correct?
Yes.
All right. Board members? Ms. Yarsh has made that motion. Is there a second?
I'll second that motion.
Thank you, Ms. Rudell. And all in favor of filing with the appropriate agencies? 6-0. Moving on.
Real brief. So there are two rules that we received some feedback on during the CSI process. Sorry, 3 rules we received questions on. I'm sorry, 4 rules. Yep, that we received questions on during the CSI process. The first has to do with 4729-5305, which is our confidentiality of patient records. This would apply to all terminal distributors of dangerous drug. The Ohio Veterinary Medical Association, you'll see on page 3 of the packet, requested that the owner of the patient have access to copies of any records, and then or any subsequent treating prescriber be authorized to have certain records from the pharmacy. It probably should be terminal distributor of dangerous drugs. Oh, yeah, there it is. And then on page 4, where we talked about all patient records maintained by a terminal distributor of dangerous drugs shall be maintained in accordance with the following. Before it just said HIPAA and all other state and federal laws, rules, and regulations. We broke that out at the request of OVMA to say for human patients they follow HIPAA, and then everybody else, in addition, all state and federal laws, rules, and regulations. So those are the changes requested by the OVMA.
About that, is there a motion to accept 47295-3-05?
So moved.
Mr. Passafume?
I'll second.
Ms. Rudell, all in favor? 6-0. Thank you.
Okay, the next set of rules have to do with emergency medical services, and mainly it has to do with the issue of posting up. You'll see in starting on the bottom of page 5 and moving to page 6, there were some concerns about the difference between posting up and posting up at a special event. Posting up really was intended so that the EMS squad goes to like a county fair that day, but then returns to the terminal distributor of dangerous drugs, license, location. Posting up at a special event in the current rule requires prior authorization by the board or the executive director of the board. What their concern was, the EMS squads were, okay, and posting up a special event means that they're there and they're continuously there for however many days for that event. And so the concern by some of the EMS squads were, okay, if I'm posting up at a special event and then something happens where this EMS squad cannot post up at this event, then I'm still beholden to get permission from the board, and if there's a short turnaround time, it's a weekend, I can't get permission to be at this event. And so what we did is modified the process to just require them to notify us, but not necessarily ask for special permission. Similar to how we used to do the pickup stations where we just wanted the notification. So this would still allow them to submit anything electronically to us and meet the requirements of the rule and still be able to post up at special events. So that's really the changes that were made in 4729-1401.
Move to approve.
Thank you, Mr. Passafume. Is there a second to that? Mr. Weaver, all in favor? 6-0. Thank you very much.
4729-51402. It has come to our attention that we are not statutorily authorized to waive the renewal fees for satellites, as well as this would make it extremely difficult for our new licensing system given the amount of EMS satellites. And so just basically asking for the removal of paragraph H, mainly because we don't necessarily have that statutory authority to do that.
All right, Mr. Weaver, is there a second?
A second.
Thank you, Mr. Wilt. All in favor? 6-0. Moving on.
And then lastly, 4729-51404 is the record keeping for EMS. Basically, this rule was just reorganized based on a little confusion from the licensed population. C was added to make sure that all the records are kept at the location that's licensed, or we do allow records from satellite to be stored at the headquarter locations if they get prior approval. So that was just included in there. And then G was also added to ensure that if they're storing, basically this is boilerplate language we're going to use in all of our record keeping language, just clarifying that all records maintained in accordance with this rule shall be uniformly maintained and made readily retrievable upon the request of an agent of the State Board of Pharmacy. And readily retrievable is defined in 4729-51401 is within 3 business days.
Perfect. Do I have a motion to accept 5-1404?
So moved.
Thank you, Mr. Passafume. Is there a second? Mr. Weaver, all in favor? 6-0.
And that concludes my presentation. Thank you, everyone.
We are going to turn it back over to Ms. Daner for the clarification on the extension of ask for the license of an intern.
Thank you. Sorry for any confusion earlier. I was able to get a hold of Ms. Clancy, and it was my confusion when I spoke with her last week. I misunderstood some of the information. So I thought that the requester had actually sat for the exam and she did not have the results. That is not correct. So let me just run through the timeline for you. Her first license was issued September of 2011. She renewed it throughout the duration of her schooling. She graduated in May of 16 and did renew timely on August 30th of 16. The rule does allow for one renewal after graduation. She has the September 18th date that I had given you earlier. That was when her approval to retest was granted. The retest has not yet actually occurred. So Chandra has been checking that on a daily basis to see when those results come in, but has not, even as of today, has not received that. And so I will give you the language of the rule in the event this helps your decision making. Basically indicates that an intern who has obtained a first professional degree in pharmacy from a school of pharmacy may renew the intern's license only once. In the event of extraordinary circumstances and when due to no fault of the intern, the board may approve additional renewals.
Mr. Weaver?
So she has scheduled her 4th exam test or has not scheduled it yet?
She has received approval to take it, but has not, we don't know when it is.
She hasn't scheduled a date, or at least hasn't given it to us?
Correct.
And what was her extraordinary circumstances for an additional extension?
That she would be thankful if she could have the renewal of her license. It would give her the opportunity to be able to work as a pharmacy intern until she takes the exam. She believes that being able to be in the pharmacy helps better prepare her for the NAPLEX, and it helps her review her knowledge and become more familiar with the medications.
And just to clarify, she's attempted the exam how many times?
3. This will be her 4th.
I'd like to make the motion for her to deny
the request.
there a second to that motion of denial?
I'll second.
Ms. Riddell. All in favor of that motion? 6-0. Thank you very much. Moving on, at this time, yep, we are going to move on to meeting minutes to get those approved and into the record. Board members, we did not have any summary suspension minutes. For minutes for the September 11th and 12th, are there any corrections or revisions that need to be?
Under R2018-072, I have that Sean and Fred.
Okay.
Not Mr. Cox. On page 76, R2018-078, I have it Josh and Kurt. Not Michael Kurt, Josh Kurt.
Okay.
That might be it. Let me get to the end. Bear with me. That's all that I see.
Any other additional corrections to the meeting minutes? Move to approve with corrections from Mr. Passafume. Is there a second? I got a second from Mr. Newland. All in favor of approving minutes? 6-0. Perfect. At this time, I'm going to read into the record cases. In the matter of Sandra Nismiro, case number 2017-1004 for dismissal of the citation. In the case of the Kroger Company, in the case of Michelle Hanschel, in the case of Trista Williamson, and the last case in the case of Carew Shore, as settlements that the board has settled prior to coming before the board. At this time, I'm going to ask, is there any additional board business that we need to address? All right. At this time, are there any additional questions from the students that we could answer for you at this time? What we're going to do is we can take a few moments to answer any additional questions that you may have at this time. And after this, we will adjourn. We'll go into executive session to discuss some board business privately. We'll be leaving and we'll be adjourning after at that point. So this is your last opportunity. We're going to bid you adieu for the rest of the day if we don't have any additional questions from you guys. Got nothing.
Thanks for sticking it out.
Well, I know. Thank you guys very much. We really appreciate everything. Your campus is beautiful. We appreciate your hospitality and everyone who has helped us out through the day, ensuring that we got from place to place for lunch and such. So we appreciate everything. At this time, I'm going to entertain a motion for executive session for board business.
I move that the board go into executive session to consider the investigation of charges or complaints against a licensee, confer with board counsel regarding a pending or imminent court action, and to discuss matters required to be confidential by law pursuant to section 121.22 (G) (1), 3 and 5 of the Ohio Revised Code.
Is there a second to the motion? I heard Mr. Rudell as a second. Mr. Newland?
Yes.
Mr. Passifium?
Yes.
Ms. Rudell? Mr. Weaver?
Yes.
Mr. Wilt?
Yes.
Ms. Yarsh? We are in executive session. And after that, oh, that's her.
I would also like to make a motion to adjourn upon conclusion of executive session.
I'll second that motion.
Thank you very much for that. All in favor of adjournment after the executive session is completed? 6-0. All right, perfect. Perfect. Thank you, guys.
Seems like nobody quite got their names, what with the excitement and all.
Thank you for joining us on Preserving America. Today we are headed to the Hancock Historic Museum in Findlay, Ohio to see a press that is credited with ending the Civil War. Come on.
The Foster Press is one of two remaining in existence today. It was an experimental design by Charles Foster of Cincinnati in 1852. He also received a patent for his design in which the toggle, or devil's tail, pushed the bed upward into the platen, creating enough pressure to force the ink into the paper. Charles Foster later sold his press and design to the Hope Press Company in 1857. The Hope Press Company then used Foster's design to improve their Washington press. The Foster Press was later discontinued in 1868. Newspapers in the 1860s were printed either once a month or once a week, depending upon the number of subscribers. Its size was similar to modern-day newspapers. A run was printed on one side and set to dry, giving the printer time to change the type and prepare to print the opposite side of the page. The dimensions were 36 inches wide and 24 inches long, then folded in half. After printing was complete, subscribers could pick up the weekly Jeffersonian, containing the NASB letters, at Locke's East Sandusky Street location.
It's understood that the NASB letters were masterpieces of ridicule. To find out more information, we went to visit a local historian, Dr. Dennis East.
David Ross Locke was born in New York State in 1833. He did have formal schooling, but most of his views were shaped by his father, Nathaniel, his views on politics, slavery, religion, the evils of alcoholism. In 1853, he started a newspaper in Plymouth, Ohio, moved later to Mansfield for a time, then to Bucyrus, and then in 1861, he came to Findlay and became the owner and publisher of the Jeffersonian, which was a Republican newspaper which supported Lincoln wholeheartedly. It was in Findlay that he developed full-blown the character of Petroleum V. Nasby, a fictional character that he used to espouse his views on the politics, the demagogues, the corruption, the war, political figures in the country at that time. I mean, the word irony, one of the critics said, was not a strong enough word to describe the sarcasm of the letters. And he used reverse logic. he made his characters so distasteful and their views so extreme and so outlandish and sometimes crude that you could not help but take the other point of view from what he was arguing in his letters.
So popular were the letters that President Lincoln wanted to switch places with Locke. He enjoyed them with such temporary excitement like a man would have found in a glass of grog. His words, not mine. The Nasby letters were always within reach. In fact, Lincoln would read them by candlelight, burning the edges of his book.
The letters had a tremendous national importance. The troops, it said, the Union troops read the letters. Lincoln was a devoted reader of Nasby letters. Even on the day of his death, he postponed a pre-theater dinner at the White House to read selections from the Nasby letters. Senator Charles Sumner of Massachusetts and Senator John Sherman of Ohio said that Lincoln told them that he would gladly give up his office in order to be able to write something like the Nasby letters. And then there's the famous attribution that the Secretary of the Treasury, Boutwell, said that the Army, the Navy, and the Nasby letters was what won the war. He's an outrageous, lying, greedy, whiskey-swilling, vulgar individual. Locke showed his disdain for the Democrats through Nasby. Locke wrote, "Humanity in the United States is divided into two classes. Them as wear clean shirts and socks, and Democrats." Let me read a selection from one of the Nasby letters about the draft and secession at the time that occurred. "I see in the papers last night that the government has instituted a draft, and that in a few weeks some hundreds of thousands of peaceable citizens will be dragged to the tented field. I know not what others may do, but as for me, I can't go. My teeth is all unsound, my palate ain't exactly right, and I've had bronchitis 31 years last June. At present, I have a cough. It's frightful to behold. I am ruptured in 9 places and am entirely enveloped with trusses. I have corns and bunions on both feet, which would prevent me from marching. The above reasons why I can't go will, I make no doubt, be sufficient." So he took an unpopular view in order to express his views and his disdain for particular policies or politicians or issues. This is Nasby's letter dealing with secession. It's written from the fictional place of Wingert's Corners here in Ohio in March of 1861. "South Carolina and several of the truly democratic states having secessed, gone off, I may say, onto a journey after their rights, Wingert's Corners, as truly democratic as any of them, has followed suit. Wingert's Corners has too long submitted to the impervious dictates of a tyrannical government. It refused to locate the state capitol at the Corners, to the great detriment of our patriotic owners. It refused to locate the penitentiary at the Corners, notwithstanding we do more toward filling it than any other state. It located the canal 100 miles from the Corners. It has never appointed any citizen of the place to any office, whether theft was possible, thus willfully keeping capital away from us. A company of Minutemen was raised, and one of 2 Minutemen. The secession flag, musket rampant, weasel conchant on a field of eggshell, waves from both groceries. Trade from Cincinnati is cut off, trade with the Black Swamp followers." So in this letter on secession, you get a sense of the sarcasm with which Nasby and Locke approached the issue of secession in 1861.
By the 1850s, the concept of typesetting and printing was becoming tradition as the trade was handed down from printer to printer. Printing was a time-consuming process that involved many intricate steps. composing, casting type, arranging individual characters into pages, pulling the press handle to make an impression from the type, and finally binding the finished product. Printing artisans drew upon a deep reservoir of accumulated knowledge, skills, and tricks of the trade. Many printers proudly referred to their craft as the art preservative of all arts. Just as an artist learns from observing techniques of other artists, the art of printing was passed along from journeyman to apprentice by demonstrating techniques and closely guarded secrets of the trade. So much that the guild and union printers swore an oath that their craft be kept secret from outsiders. Apprentice printers, called devils back then, learned to manipulate type and arrange it into eye-pleasing combinations through verbal instructions from a journeyman or master printer. They discovered which type designs were appropriate to a particular job by imitating the experts by experimenting on their own. Sometimes they needed to know how to operate a printing press, mix inks, bind books, and other skills involved in the total process. Ironically, very little of this information was passed along by way of the printed word. Tradition, customs, and techniques were orally transmitted and not printed. Newcomers to the trade listened and imitated as older workers handed down knowledge that began accumulating in the late 1400s.
Hi, my name is Malcolm Collum. I'm a conservator at the Henry Ford Museum in Dearborn, Michigan. And I'm responsible for about 500,000 artifacts here at the museum in Greenfield Village. And one of those artifacts is the 1853 Foster printing press. You can see off to my right. This is one of many presses that we have in our collection. And some of the many issues that I'm concerned with are corrosion. When we have a rare printing press like our Foster press right here, if we have artifacts that have original surfaces, original paint surfaces, show evidence from when they were last used, in this case, something that was used over 150 years ago, our main goal is to try to preserve those the evidences of use and try to truly represent how the printing press would have looked back then, and to sort of maintain its original character and patina. I'm trained as a fine art conservator, but I'm actually one of the few conservators in the country who's sort of transferred my training as a fine art conservator into the preservation of historic machinery, mechanical artifacts. So although it sounds a little ridiculous, we actually use the same techniques and materials that a conservator who's restoring a Rembrandt painting or some other fine artwork in an art museum, we use those same techniques and materials to preserve paint flaking on an iron industrial artifact. And knowing that the forces of nature are always against us, paints will slowly begin to degrade. As you know, on your house, you have to repaint a house every so often. Same thing with paint on a 150-year-old printing press. So there are a number of techniques that are practiced by conservators. The same sort of techniques and procedures and materials that are used by fine art conservators in the preservation of paintings and other works of fine art you find in museums across the country. We use those same techniques and materials to preserve historic machinery and artifacts, vehicles, aircraft, and industrial machinery. With 1.5 million visitors, if say 1 in every 1,000 visitors decides to go snoop around and pull on things and climb on stuff and be a bit of a hooligan, that actually adds up over the years. So one of our main concerns is, putting in barriers to keep visitors away, and usually incorporating text into that barrier, but making the barrier not so obtrusive that it really looks like it's behind a glass bubble. Now, with an artifact of this type, where you have bare exposed steel surfaces and painted surfaces, our main concern is for the protection of those bare steel surfaces. Whenever somebody touches exposed iron, it sort of creates a small battery-like situation where the oils and salts in your sweat are incredibly corrosive. You may see that sometimes on a freshly polished piece of brassware. It can show fingerprints within a day or two. And so whenever a visitor or a staff member touches the bare steel surfaces on an artifact like this, they're leaving behind a little residue, which actually creates a small little cell. And if you live in Michigan like I do and know what it's like when they salt the roads, that sort of same action that you see on the body panels of a motorized vehicle will happen on a small scale on an artifact like this. Albeit it happens at a much slower rate, but the surfaces will corrode and become permanently damaged. So with that in mind, whenever we would treat an artifact like this, the first thing we do is we clean all the surfaces. And we'll use low polarity solvents like mineral spirits, and that removes the oils and also carries out some of the salts and other contaminant residues that are on the surface. And the low polarity solvents also doesn't dissolve any original surfaces like some of the paint that may be left on here, any evidence of use. So for example, if we were to remove this press from our storage facility, and knowing that we're going to put it on display for maybe 10 years in a long-term exhibit, first things we'd do would be to degrease the surface with mineral spirits and look for any evidence of use. One of our main jobs is to document the existing conditions, so any flaking paint, any damage, any missing bits of leather, any cracks that we might see in the structure. That's another main concern with any sort of historic artifact like this, is that they typically tend to be made of cast iron, and although it's made of iron, one might typically think that it's really durable, but cast iron is actually incredibly brittle. So moving an artifact of this weight and scale is quite a challenge, and we typically hire out experienced riggers to do work like that. Just a slight jar or bump into something could easily break one of these main pillars, and that would be quite a catastrophe. So it is amazing that artifacts like this have survived for 150 years, and it's great to be able to see these things in museums. So once we've cleaned the entire surface of a printing press like this, one of the first things we do is look around for any sort of evidence of active corrosion. And what I mean by active corrosion is any sort of areas where there's a bright red or yellow or orange colored rust, basically. Most of the surfaces that you see on here, even though they're iron, they're a nice dark brown or black surface, and that's considered to be a fairly stable corrosion product, and we like to leave that intact because it gives the piece an overall nice level of patina. It shows that it's been worn, it shows that it's been in use, and it looks like a 150-year-old piece of machinery, as it should. It's been aging gracefully. If there are bright spots of corrosion, then we have to deal with those immediately, because that is active corrosion. It's actually eroding the surface of the metal. And when you see areas of active corrosion, it's typically because there's some sort of contamination, usually caused by salt. And just as you would find on the body of your car, really the best technique is to remove all of that corrosion and get it all the way down to the base metal, and then apply your protective coatings. But if you leave salt on the surface of bare iron and the humidity goes high, or if it gets wet for some reason, it will begin to actively corrode once again. After we've removed the corrosion and we're assured that all of the chlorides or whatever that contaminant is that's actually causing the active corrosion has been removed, then we would usually follow up with sort of it's kind of an added level of security. And we use tannic acid. Tannic acid is great for complexing with iron surfaces. It'll go in there and form a black ferric tannate, which is a very stable corrosion product. And that's very similar to the kind of surfaces we have here. It's nice, rich black, almost kind of a deep brown color. And this surface is incredibly durable and corrosion resistant. And tannic acid is basically, it comes in sort of a light brown powder, and we mix it to about a 5% solution in distilled water, and just literally brush it on or swab it onto the bare iron surfaces. It turns into this dark brown surface, and then we'll go back and we'll rub back that surface so it has kind of a hand-worn, nice, even, mellow surface. After we've done the tannic acid treatment, then we'll typically follow up with an application of a microcrystalline wax, which is a very purified wax coating, and it's very stable, it's very hard. An artifact like this, it's on display for literally, potentially decades at a time. If you think about just routine cleaning, a cleaning person comes through here once every day, once every other day with a duster or a rag. Every little bit of cleaning will erode that surface unless you've protected it with some sort of hard coating. And the microcrystalline wax seems to work very well. With artifacts that are in really close proximity to the public, typically surfaces like that will put a lacquer coating. We tend to use a material called agatine, which is incredibly hard, it's durable, but yet it's very reversible. So the application of acetone, which is an organic solvent, will just easily remove that coating from any bare steel surfaces. The problem with coatings like that is that sometimes you could trap contaminants underneath the surface, and so you'll get some potential corrosion issues there. Once it's in an environment like this where it's protected from visitors handling, and the museum is environmentally controlled, and we like to keep the environment to roughly 50%, maybe plus or minus 5%, and at a nice comfortable level year-round, which is around 70, 72 degrees. At those climate conditions, it tends to be good for wooden artifacts, and it's also good for iron artifacts. Iron surfaces will begin to corrode at about 65% humidity. However, if they're contaminated with salts, they'll tend to corrode at even lower humidity. So that's because salts are so incredibly aggressive. So once we do a treatment like that and it goes out on display, this thing should be fairly maintenance-free for, it could be decades really. But it's great to have the cleaning staff and periodic inspections done by the conservation staff here at the museum to go around through the collections and look for any new damages. If we see any bright yellow or orange corrosion, then we have to treat it right away. If we see any evidence of paint, if we see little crumbles of paint on the floor, we come out here right away and we make sure that we get in here and we treat the paint, because that's one of the main issues, is trying to keep the surfaces as original as possible. Now, another philosophy that we have at the museum here is not only preserving surface patinas and original paint layers, but it's also the preservation of intended function. This was meant to be a printing press. It was meant to print out flyers, newspapers, other sort of information to the public. And one of our other sort of main philosophies is to preserve the intended function. For obvious reasons, we don't use this press, because whenever you use something, you're causing wear, you're introducing the potential for serious damage, catastrophic damage, things to break, and that's irreversible damage. We do that with motorized vehicles. There's only a small percentage of the motorized vehicles in our collection that we actually keep in running condition. But at the same time, we make sure that all the engines are lubricated, we make sure that all the grease fittings are greased periodically, so that original intended, it's a vehicle that's meant to be driven. If they want to drive that thing in 300 years, they'll be able to do that. And same thing with a printing press like this. You can see that they've got small little oil holes in all of the mechanical pivot points, and little things like this we like to keep lubricated. We'll go in, and rather than using a traditional type of lubricant, which will break down and degrade and become oxidized and actually become acidic and erode away at bearing surfaces, we tend to use synthetic greases and pure synthetic oils, so that that mechanical pivot there, if corrosion did develop there, we're not going to know about it because it's buried, it's trapped. So there could be active degradation going on inside some of these mechanical points. There are pivot points here, there's a pivot point here, and here, and here. This shaft here has to pivot. All of these mechanical components have to be lubricated. And what we typically like to do is, whenever we have a mechanical machinery, luckily this is a very simple machine, we like to disassemble it as much as possible so that we can get into those tight little mechanical points. And we'll find old lubricants that are literally hard as a rock. We have to scrape them out of there. And we'll replace them with other similar viscosity lubricants, like a synthetic grease or a heavy synthetic oil. And when we reassemble it, we know that that mechanical point is now clean, and that those old lubricants that were in there becoming acidic and pasty will not be eroding away bronze bearings or etching into the steel surfaces.
Thank you for joining us on Preserving America. Join us next time as we discover America's lost treasures in its museums and archives.
Hello, everyone. Glad you're here. Welcome to Point of the Evening 17. I believe this is our 11th annual fundraiser for the Chance to Dance Foundation. For those of you who don't know who I am, my name is Judy Reading, and I'm a ballet professional. I'm the ballet professional at the Findlay Academy of Ballet. The Chance to Dance Foundation. What do? Well, we provide scholarship assistance to kids and families who otherwise would not be able to dance. And I think that we have some pretty outstanding kids. They're devoted, they're disciplined, they're strong in focus. So I think we have a lot of youth in our dance community and kids that I love helping. And we can only do this with your support. So when you think about why you're here and what you might do to help us, first of all, I might tell you also what we do to help them. We provide financial assistance for classes, for point shoes, which are very expensive, maybe $80 a pair, and the level 6s and the advanced dancers go through them way too fast, their parents tell me. It also provides master classes. We hire professional teachers to come in so that these students can take from other professional dancers. We're trying to help them go down that road of discovery, to be aware, to learn things. They're wonderful students, again, because I said they really know what hard work is. Hard work, you have to be. By the very essence of ballet, you have to work hard. It takes 10 years of taking ballet class every single day to become an accomplished ballet dancer. It takes strength that you cannot believe. I know you all go to your sports games and you scream and cheer for everyone, and they're throwing themselves all over the field and they're perspiring, and you come here and you probably think, oh, it doesn't take any strength for these dancers to do what they're doing. I invite you to come backstage sometime when the NEOS dancers are coming off stage or when the level 6 dancers are coming off stage. It's as though they have just been out on that field for the last 2 hours. They're exhausted. So I would encourage you all to think about that, because we're trying to help youth in our community. Everything that you give tonight, including the seat that you're sitting in, helps these kids and the Chance to Dance Foundation, therefore, to help them. So I would hope that some things out there in the silent auction you might be interested in. We also have raffle tickets that are being sold for the Stranahan Theater, 2 sets of tickets. We have the American Girl Doll of the Year. All of that will be raffled off. After the intermission, we'll have some young ballet students up here on stage, and they'll draw the ticket for that. The silent auction will be open until the end of the intermission. After that, after the performance, when you go out front, you'll see a board that will tell you whether you're the winner of your particular auction item, and there will be lines for you to get into to pay and pick up your item. Let's see. Oh, I know, really, really important. You might have noticed that there are some ladies with shirts identifying them from Kohl's. They're wonderful. They engaged us. They love what we do for kids, for the Chance to Dance Foundation. They gave us a huge contribution this year, which we're so thankful for. And then they sent 5 volunteers from their store here in Findlay to help us tonight. So Coles, I think you're wonderful. Thank you very, very much. Yeah. There are also DVDs capturing the magic of tonight's performance. So that's something else. If you buy a DVD, you're helping a kid in dance. If you purchase something from the silent auction, you're helping another really hard-working child. If you buy a raffle ticket, you're helping us. If you give a donation, you're helping us. So you might just want to think about all of that tonight. Afterwards, there's an opportunity to meet and greet the dancers, not only from the Findlay Academy of Ballet, but from NEOS. There's food, there's drink, lots of happy chatter, and we'll all be glad to see you, so we hope that all of you